The Committee on State and Local Government and Veterans Committee will come to order 11:08, March 19, 2024. We do have a number of bills on the agenda today. If we do not finish our work by 2:30, we will be coming back this evening at 5:30 in room 1100. So that would be a different room than normal. Okay, with that said, thank you, Senator Klein, for coming to the committee, and you can present your bill at your convenience.
Thank you, Chair Mitchell and committee. I have two bills today that are department bills, policy bills from the Department of Commerce. Both of them have already passed with unanimous voice votes out of the Commerce Committee. They come to you because of rulemaking provisions. I will begin with Senate File 4156, the Commerce Security Policy Bill. This includes updates to statutes and direction to the department to do rulemaking that will allow the Commerce Department to better serve Minnesota's investment advisor representatives, investors, consumers, and businesses. And I have a testifier.
Thank you. If you could please proceed and state your name for the record.
Thank you, Chair and members. For the record, John Kelly, Director of Government Affairs for the Minnesota Department of Commerce. For the state gov-related provisions of this bill, the Commerce Department would be directed under the good cause exemption to implement the NASA, the North American Securities Administrators Association Model Investment Advisor Representative CE rule. And so this would bring us into alignment with 18 other states, including Wisconsin and North Dakota. We have worked with the Financial Planners Association and others. This isn't adding necessarily additional CE. It's just bringing consistency across the required CE for folks, and it's an important update to our rules governing continuing education for investment advisors.
Thank you. I believe there is also an oral amendment to this.
Madam Chair, that'll be on the next bill.
I apologize.
Oh, no, I'm sorry. You're right. This is on this bill. Yeah,
Oh.
I'll ask counsel to explain the oral amendment. Yeah.
Thank you. Counsel?
Madam Chair and members, on page 11, line 23, the amendment would be to insert a comma after the word registration.
Senator McEwen moves that the oral amendment adding a comma on 11.23 after the word registration be accepted as an oral amendment. All in favor, please say aye. Aye. Opposed, nay. The motion prevails. The amendment is adopted. Senator Klein, you can continue.
That's the bill, Madam Chair and committee.
Thank you. Do the committee members have any? Senator Anderson.
Thank you, Madam Chair. Senator Klein, or to your testifier, what makes us non-compliant now? You mentioned that this will bring us in compliant, or the rules that are going to be made will be, what makes us now as a state not compliant?
Madam Chair, Senator, we're not in compliance. We're modernizing our investment advisor representative requirements in Minnesota rules and just getting into alignment with other states. A lot of our licensees do business across state lines, and we want to just have it be continuously the same across our states.
Thank you.
Thank you, Senator Anderson, for the question. Seeing no other questions or comments, Senator Carlson moves that Senate File 4156 as amended pass and Senator Klein, do you know where this is being referred to? I don't have the annotated agenda in front of me.
Chair Mitchell, if you want to move it to the Commerce Committee, then.
Thank you. Senator Carlson moves that Senate File 4156 as amended be recommended to pass and be referred to the Commerce Committee. All in favor, please say aye.
Aye.
Aye. Opposed, nay. Seeing the motion as amended. The motion prevails, and Senate File 4156 as amended is referred to the Commerce Committee. Thank you, Senator Klein. Up next is also Senator Klein with Senate File 4157. Senator Klein, please proceed.
Thank you, Chair Mitchell and committee. Senate File 4157 is the department's financial institutions policy bill, and it updates Minnesota banking statutes and rules by replacing the deputy commissioner as the final approval for detached facility applications with the financial institutions chief examiner, among other things, and Mr. Kelly can speak to the bill more fully. I'm also going to, after Mr. Kelly speaks, ask the assistance of the committee in taking 3 amendments. One of them, I can explain them as they come, but one of them will respond to concerns and resolve concerns from the banking industry. The other will add in the Data Security Model Act, also a department bill. And the third will clean up the bill a bit.
Thank you, Senator Klein. Senator Klein offers first, is asking for the A2 amendment. Senator Swazinski offers the A2 amendment. All in favor of the A2 amendment, please say aye. Aye. Opposed, say nay. The amendment is adopted. Senator Klein is also would like us to look at the A3 amendment to get the bill in the shape that he wants it in. Senator Gustafson offers the A3 amendment. All in favor, please say aye. Aye. All opposed, nay. The A3 amendment is also adopted. The motion prevails. The amendment is adopted. Senator Klein, did you say there was a third?
Yeah, Madam Chair, yes, and thank you for the indulgence of the committee in passing both of those amendments. When Mr. Kelly speaks, he can describe what each of them accomplished. It's non-controversial policy material. And then lastly, there's a provision within the bill which will send this entire bill to judiciary. We're going to try to speed things up and handle that in a different bill. So, Madam Chair, I'd like to have council describe an oral amendment that would delete Section 12 from the underlying bill, Senate File 4157.
Council James.
Madam Chair and members, the amendment would be on page 10, delete section 12.
Thank you.
Madam Chair.
Senator McQuaid.
Thank you, Madam Chair. Senator Klein, would you be willing to just say like 2 more things about the amendment?
Senator Klein.
Madam Chair and committee, I'll have Mr. Kelly speak to that.
Mr. Kelly, we're on another bill, so could you please state your name and title for the record?
Yes, thank you, Madam Chair, members. John Kelly, Director of Government Affairs for the Minnesota Department of Commerce. This provision in Senate File 4157 pertains to background checks in our mortgage industry. We're trying to harmonize the different requirements for our mortgage industry. We are going to take that out. The amendment would take that out of the bill, and we are going to, the plan is to amend that onto a bill that is a department bill that's going to judiciary, and then put them back together in the markup.
Thank you. Senator McQuaid. With that, Senator McQuaid moves. Oh, Senator Drazkowski.
Madam Chair, I've just got a series of questions here about process. I was just handed a packet of a bill and some amendments. I don't see our bills. We've got 19 bills today, I'm told. Are they coming?
Yes, Senator Drazkowski, because there was a large number of bills that wouldn't actually fit well in the packets, and there is a chance that with people getting to different committees that they might be reordered, which would add to confusion. They are being passed out as each bill is starting. Everything was also posted online.
Well, Madam Chair, this is the first opportunity for me with my time to read these bills, and it would be helpful if we had them before us. The other committees I've been in have had numbers of bills, and they have them available. Also, could we're seeing amendments here that belong in commerce, not in state government, state and local government. I'm not on the Commerce Committee, and I don't know if you are, but at a minimum, it would be helpful if the bill and the amendments were described to us, and if we could walk through them. These are significant amendments, Madam Chair.
Senator Drazkowski, as is usually the custom for bills first stop, we help the author get it in the order that the author would like it into. The committees I've been in, we usually do what we're doing here, which is take the amendments, and then I know Senator Klein will be explaining the bill in its entirety. I've also given the opportunity on any of the amendments to ask questions at that time, but I know that we have already heard that they will be explaining everything once we get it in order, both with the amendments covered and the entire bill.
So, Madam Chair, this is not the first stop for the bill. The originating committee on this is the Commerce Committee, as it should be. These amendments that are brought forward, again, significant amendments, are related to commerce definitions and federally insured depository financial institution. They should be judged in the face of the Commerce Committee in their expertise and understanding of the bill. This isn't something that is state government related. This, the last bill was, and it was rulemaking. That was what we were providing as a committee the scrutiny for. For us to provide scrutiny for a large 14-page amendment, I don't know.
Senator Drazkowski, the amendment has been adopted. Are you asking to reconsider?
Madam Chair, we spent the first 2 weeks in this committee doing nothing. The first 2 weeks of session, there wasn't any committee meetings, there was nothing going on. If indeed the business requires this type of flurry of activities where this stuff is just pushed through out of context of the originating committee that it should be judged in, this appears to be mismanagement, Madam Chair. I struggle with the way this process is beginning, and if this is going to continue through the rest of the 19 bills, the people of Minnesota are going to be victimized by the mismanagement here.
Senator Drazkowski, again, the amendment has been adopted. Are you asking for the amendment to be reconsidered?
Well, Madam Chair, yeah, I'll move to reconsider the bill. I didn't vote. Was it an oral vote, Madam Chair?
Yes, Senator
I didn't vote on the
Drazkowski, and it
prevailing
prevailed.
side. I didn't even vote because I wasn't trying to come up to speed on what we had in front of us here. So maybe somebody who voted on the prevailing side would like to reconsider.
You do not have to vote on the prevailing side in a committee to ask for a reconsider.
Well, if that's what they say, Madam Chair, I move to reconsider the A3 amendment to start.
There is a motion to reconsider the A3 amendment.
And a roll call, if we could, Madam Chair.
A roll call has been requested. A roll call will be granted. Please take the roll.
Chair Mitchell,
No.
Chair Dietzick,
No.
Senator Anderson,
Yes.
Senator Barr,
Aye.
Senator Carlson,
No.
Senator Swedzinski.
Nope.
Senator Drazkowski,
Aye.
Senator Fateh,
No.
Senator Gustafson,
No.
Senator Jasinski,
Yes.
Senator Coran,
Yes.
Senator Lang,
Yes.
Senator McEwen,
Nay.
Senator Morrison.
Nope.
With 6 yes and 8 no, the motion fails.
Madam Chair, if I could we move to reconsider the A2 amendment?
Senator Drazkowski moves to reconsider the A2 amendment. All in favor, say aye.
Roll call, Madam Chair.
A roll call has been requested. A roll call will be
Madam
granted.
Chair. Never mind, continue, sorry.
Please take the roll.
Chair Mitchell,
No.
Chair Dietzig,
No.
Senator Anderson,
Yes.
Senator Barr,
Aye.
Senator Carlson,
No.
Senator Spodzinski,
No.
Senator Drazkowski,
Aye.
Senator Fateh,
No.
Senator Gustafson,
No.
Senator Jasinski,
Aye.
Senator Coran,
Yes.
Senator Lang,
Aye.
Senator McQuaid,
No.
Senator Morrison.
No.
With 6 yeses and 8 noes, the motion does not prevail.
Madam Chair,
Senator Cran.
since no reconsideration for the amendments, and now that the bill is in the form that,
Senator Cran, we were actually in the middle of an oral amendment when this began.
yeah, Madam Chair, I'm asking, before final passage of the bill or you move, I believe it's incumbent then to at least have a conversation and have the testifier talk about what's actually changed and in the amendment. I understand we're not the committee of jurisdiction, but these were just added. You've avoided that, so I think we're due. If you're going to accept and adopt it, we should at least hear the explanation of what's changed and have a debate about it.
Senator Cran, the testifier has already made a commitment to explain everything after the amendments were added. And we were in the middle of the oral amendment. Senator McQuaid moves that the oral amendment as described to delete section 12 on page 10 is adopted. All in favor, please say aye. Aye.
Aye.
Aye.
All opposed, please say nay.
No.
The motion prevails. The oral amendment is adopted. With that, I believe the bill is in the shape that the author desires. Could you please now testify to the bill?
Madam Chair and Committee, and Senator Drazkowski, entire respect for your concerns about process, and I guarantee that this is coming back to Commerce, which is in fact the Committee of Origin, and Mr. Kelly will speak to why the amendments you adopted really are pertinent to this committee and have rulemaking and why we handled it in the way we did. I was not trying to sneak around process or undermine the work of the good state government committee. And with that, I will turn over an explanation of the bill as amended to Mr. Kelly.
Please proceed and state your name again for the record.
Madam Chair, John Kelly, Director of Government Affairs for the Minnesota Department of Commerce. So the Data Security Model Act and the 4157, the Financial Institutions Policy Bill, are both bills that relate to the Financial Institutions Division, both banking and non-banking side, and we're combining those bills into one bill. They were originally moving as two bills. The Data Security Model Act, which is Senate File 4376, which was amended in the bill, Section 5 of that amendment has a rulemaking provision that establishes the state's ability to continue enforcement and supervision of this critical area should the FTC safeguards rule be repealed. The CSBS Model Law Drafting Working Group felt this language was necessary since the model law is so dependent on the FTC safeguards rule. The goal is to provide a safety net for states in case anything ever happens to the FTC safeguards rule. The overlying bill is that was added via amendment to our FI policy bill. They're both FI policy bills from the department. Is the CSBS Non-Bank Data Security Act. It is largely based on the Federal Trade Commission safeguard rule, and it establishes comprehensive standards for data security in non-depository financial institutions to protect the sensitive information and mitigate cyber threats. The all three of our FI division bills, the securities bill, the FI policy, and this bill required state gov stop since there's rulemaking provisions, and we've combined the two non-depository side bills into one, and it's going back to Commerce and will be heard, the full data security provisions in the Commerce Committee. It's just hitting all three state gov stops. Madam Chair.
Thank you. Senator Klein, anything else before we open it for questions? Thank you. Senator Drazkowski.
Thank you, Madam Chair. In the A2 amendment portion of the bill as adopted, on lines 13.10 and 13.11, it outlines the rulemaking authority that this attempts to give the department. I'm wondering if staff could help us out, or somebody, maybe the author could tell us more. Normally, rulemaking authority provides a citation that tells us what type, whether it's regular rulemaking authority. Help us out, staff, the expedited approach, and there's about 2 or 3 or 4 types of rulemaking. Can we tell from this language what type of rulemaking we have?
Ms. James.
Madam Chair and members, this would be ordinary rulemaking, full rulemaking.
Thank you, Ms. James. Thank you, Madam Chair.
Any other questions? Senator Anderson.
Thank you, Madam Chair. Mr. Kelly, the rulemaking that's on page 18 says rulemaking. It talks about complying with changes made in the Act. What were those changes that were made in the Act that we discussed in the first bill, 4156?
Mr. Kelly.
Madam Chair, my understanding is that that's referring to the underlying bill. No. I'm not quite sure. I believe it's talking about 4156.
Thank you.
So, Madam Chair, Mr. Kelly, we're making changes to the Act that was passed in 4156, and we just made changes by adding the A2, the A3, and the oral amendment to that. Are they considered the changes also?
Ms. James is going to jump in.
Madam Chair, Senator Anderson, and members, the rulemaking in Section 21 of the underlying bill, which starts on page 18, line 26, that provides for the commissioner to amend a specific rule to comply with the changes in the Act. So this rulemaking, which allows the use of the good cause exemption, only applies to the changes to that specific rule.
Thank you, Ms. James.
Thank you.
Seeing no other questions, Senator Carlson moves that Senate File 4157 as amended be recommended to pass and sent to the Commerce and Consumer Protection Committee. All in favor, please say aye. Aye. All opposed, nay.
No. Division.
A division has been called. Can ayes please raise your hand? Noes, please raise your hand. With 8 yes and 5 no, the motion prevails. Senate File 4157 as amended has passed and will be sent to the Commerce and Consumer Protection Committee. Senator Klein, thank you.
Thank you, Chair and Committee.
Up next is Senate File 4784, Senator Frentz. Senator Frentz, before you begin, I just want to remind everyone, the committee members, that our jurisdiction in some of these bills is limited. For this, specific to this committee, it is Article 3, Section 14, requiring the Commissioner of Commerce and the Environmental Quality Board to adopt rules using the expedited process conform with statutory changes, and the PUC to amend a rule in a specified way. With all of that kind of clarified and narrowed for our committee, Senator Frentz, if you could please proceed.
Thank you very much, Madam Chair. Members, proud to bring before you Senate File 4784, the Permitting Reform Act. As the chair has already described, I'm here for one part of that bill, page 31, the final page, section 14, which essentially requires rulemaking. I'll just give you the briefest of descriptions of why we're here in State Gov. And Madam Chair, at some point, I'm hoping one of your committee members will move this back to the Energy Committee, my committee, for hearing tomorrow for the fiscal note. Members, the permitting reform bill is essentially the state's stakeholder group effort to slim down the amount of time to permit energy transmission. There's a lot to be talked about in energy. There's a lot to be talked about the cost and timing. The part that relates to state government is that we are taking some rules and putting them into statute. We think this is the right way to make sort of a one-stop place in the statutes for people who want to permit. The goal here is to save a year of total permitting time. However, on page 31 in section 14, rule 4410 of the Environmental Quality Board has had rules put into statute in the bill. As amended, it would mean then that we are asking the EQB and Commerce to make rules to conform to the statutes that are now in the bill. That is the sole reason that I've come to you in state government today, is to ask for your permission to send the bill on, essentially saying that the EQB and Commerce, which relates to site and route permitting, will make rules in conformity. And Madam Chair, I'm happy to say more, but I don't really know if that's necessary.
Thank you, Senator Frentz. We will see if there are questions in a minute. I do believe there is a testifier. Ms. Christensen, if you could please proceed. And if we can try and keep the testimonies tight today, that would be helpful.
Yes, Madam Chair, if the scope is that small, we will skip it for today.
Oh, I wasn't trying to get you not to testify. Okay, thank you. With that, Senator Klein, or I'm sorry, Senator Frentz stands for any questions. Committee members, do we have any questions? Senator Drazkowski.
Thank you, Madam Chair. Thanks, Senator Frentz. On section 14, the administrative rulemaking there, they're requesting expedited rulemaking. Why can't they use the normal rulemaking process? Why do they have to use the expediting process that provides for less public input?
Senator Frentz.
Thank you, Madam Chair. Thank you, Senator Drazkowski. Just to be clear, you're asking me why that is in the overall bill, or why we're asking state government to approve the rulemaking for expedited?
Senator Drazkowski.
Why it's in the bill, Senator Frentz.
Senator Frentz.
Thank you, Madam Chair. Thank you, Senator Drazkowski. The point of the bill includes speeding up our permitting. The state has not reformed its energy transmission permitting in 40 years. In this instance, the stakeholder group submitted a report to the Public Utilities Commission after 3 meetings. These provisions in the bill are the 14 most consensus of the 34 that they recommended, and one of them includes expedited rulemaking for this purpose. Again, Rule 7850, site and route permitting. It does not prevent all the other input on either environmental or efficiency concerns, and what we're saying is the bill would require the EQB and Commerce to make rules to allow for this when they're in statute, should the bill pass. I hope that's a good enough explanation.
Thank you. Senator Drazkowski.
Thank you, Madam Chair. Senator Frentz, I think it is, but what expedited rulemaking does is it provides a process that the public gets locked out of the type of feedback and input that they normally have in the normal process. Senator Frentz, we've been going along with energy permitting that is slow and non-responsive to the people of Minnesota for many years, and so I haven't looked at the details of what's being proposed here, but if indeed that's what's going on, I applaud that. But to lock the public out of the level of input that normally is afforded through the normal rulemaking process seems to be short-sighted. I mean, we should give people the ability to have the best process so that the agencies do what they need to do in order to accommodate fully what is envisioned in the bill and the proposal. Because I don't know about you, Senator Frentz, I don't trust the agencies very much to do the will of the people to the extent that that they are desiring. And if we give ordinary rulemaking authority to them instead of this limited time and input through the expedited process, then I think we're going to have a better product.
Thank you.
Madam Chair, I'd be interested in Senator Frentz's response.
Oh, Senator Frentz.
Thank you, Madam Chair. And Senator Drazkowski, I agree with you that we want to have robust public input, again, on the timing, on property rights, on the environmental review, and on costs. In the bill, there are choices being made that will expedite the amount of time. Again, it's estimated the bill, if enacted, would save about a year in permitting time over what is about a 4.5 year process. But I respect those who say that there are places when we should slow down. Looking forward to that debate when we get back to energy tomorrow, if I'm lucky enough to get out of this committee. And I think you'll have a chance to say why you prefer ordinary rulemaking. As for the trust for agencies, Madam Chair, my experience has been that they're hardworking Minnesotans trying to get things right. But the greatest pressure for permitting reform is coming from the extra amount of time and prepare for forward spin. I think we'll have this discussion in some other areas of permitting outside of energy transmission, and we should, about how we value the public input and how much time it takes. Also, Madam Chair, there are instances where the public input is not changed, but it is moved more to the front of the process. And so many places in the bill where the public can still weigh in, but at an earlier time. And our hope is that that will allow for problems to be identified sooner and hopefully smooth the process. But looking forward to continuing the conversation.
Thank you, Senator Frentz.
Madam Chair,
Senator Drazkowski.
I'm wondering if staff or somebody could give us, because it's been a while since I've had this type of discussion here in the legislature, an understanding of what type of time horizon we're looking at in ordinary rulemaking versus, and maybe Ms. James could give us the 30-second or 1-minute overview of the different rulemaking processes, how long they take, and what type of public input they include.
Ms. James.
Madam Chair and members, the timeline is probably pretty specific to the kind of rules that have to be adopted, but as a very, very general guideline, full rulemaking can take a couple of years. An expedited process still provides for some degree of review by the ALJ, but you're right, Senator Drazkowski, that there's no hearing and there's no sonar, that is a statement of need and reasonableness that would be generated from this, and the review by the ALJ is more limited than in full rulemaking. I can't speak to how long this expedited rulemaking would take. I don't know, 4 months, 6 months. The agencies involved here might be better able to speak to that. Is there any other specific questions that I can answer? Okay.
That's helpful, Ms. James. Thank you.
Thank you, Ms. James. Seeing no further questions, Senator Anderson.
Thank you, Madam Chair. I think because of what was just mentioned about the expedited process, unless Senator Frentz would like to change that process to a full process, or a process that would take longer and allow for public input into the bill, into the guidelines that are being proposed here in the bill, I would like to have a roll call on this bill.
A roll call has been requested. A roll call would be answered, or will be granted. Senator Frentz, any response to that and any final comments?
No, but I, again, want to thank you, Madam Chair, and thank you, members. I know you got a full agenda today. I believe that this will be one of the things that we'll do in a bipartisan fashion this year, that we'll be able to say to Minnesotans, we reformed, we worked on, we updated, and we improved this particular area of permitting. And Senator Drazkowski, Senator Anderson, I think we'll be able to point to this in some other areas where I know many of us on both sides of the aisle would like to see some permitting reform, and say the template of stakeholder group, report of stakeholder group, review, and then bringing it here to the legislature is going to prove to be a durable and successful approach. Thanks, Madam Chair.
Thank you, Senator Frentz. With that, Senator Morrison moves that Senate File 4784 be recommended to pass and referred to the Energy, Utility, Environment, and Climate Committee. A roll call has been requested. Can you please take the roll?
Chair Mitchell,
Aye.
Chair Dietzig,
Aye.
Senator Anderson,
No.
Senator Barr,
Nay.
Senator Carlson,
Aye.
Senator Swedzinski,
Yep.
Senator Drazkowski,
No.
Senator Fateh,
Aye.
Senator Gustafson,
Yes.
Senator Jasinski, Senator Coran,
No.
Senator Lang, Senator McQuaid,
Aye.
Senator Morrison,
Aye.
Senator Jasinski,
With there being 8 yes votes and 5 no votes, the motion prevails. Senate File 4157, or I'm sorry, Senate File 4784 has passed and is referred to the Energy, Utility, Environment, and Climate Committee. Thank you, Senator Frentz.
Thank you, Madam Chair and members.
We are going to switch the order slightly because Senator Kupec is with us now, and so we are moving to Senate File 3523. Senator Kupec, when you are able, you can proceed. At your convenience.
Sure. Thank you, Madam Chair. And I believe we do have an amendment to the bill. Do we have the, or did we do? No,
We should have done.
Sorry, we already did that. We did that one in judiciary. Take that back. Do not have an amendment to the bill. So the bill here before you today creates a new licensure for what is known as a behavioral analyst. If you look in the folder, there's handouts. The states all around us have licensed behavior analysts, some of them for quite a while. And what this has led to, and particularly one of the constituents in my district brought this forward, is that, say, for instance, a behavioral analyst who's licensed in North Dakota does something against their license, they could then just slip across the border into Minnesota and set up shop again and continue on. There would be no repercussions because we do not have any licenses for behavioral analysts. It also means that somebody like me, who really does not have any expertise as being a behavioral analyst, could just say I'm a behavioral analyst and not have to go through any kind of licensing program. So the Board of Psychology will oversee this, and they are supportive of this. And so this will just set up a new tier of licensure going forward.
Thank you, Senator Kupec. And I didn't have a testifier on the record. Are you just here for support?
My name is Samuel Sands. I'm the Executive Director of the Minnesota Board of Psychology. I'm here to answer questions, should there be any questions for the board.
Thank you. And this bill would be laid over for inclusion. Does anyone have any questions? Seeing no, Senator Drazkowski.
Thank you, Madam Chair. I'm wondering if the gentleman from the Board of Psychology would answer a question. That would be, would this give your board more power?
Could you please state your name again for the record and your title?
My name is Samuel Sands. I'm the Executive Director of the Minnesota Board of Psychology. Madam Chair, Senator Drazkowski, this gives the board the authority to regulate a new profession, a new license type. So in that sense, they would be able to regulate those individuals, but this doesn't give us any tools that we don't already have when regulating the practice of psychology in the state of Minnesota.
Thank you.
So, Madam Chair,
Senator Drazkowski?
another question so if indeed it gives the authority for the board to license and regulate, that sounds to me to be more, you've got more authority, right? That's, authority is power. Maybe it's not a question, Madam Chair. Maybe it's just a comment. This is building and making the government bigger. So just good to know what we have in front of us. Thank you, Madam Chair.
Thank you. Senator McEwen?
Thank you, Madam Chair, and Senator Kupec, I'm really glad you brought this bill forward. I think reading about the work that behavior analysts do with incredibly vulnerable populations, in particular children, and then knowing that it is entirely unregulated in the state of Minnesota is concerning, but also exciting when industry brings forward its own regulatory desires. So I'm really glad that you brought forward this bill. My only question is, I'm not a number guesser. And so I know we're laying this over, but is there any guesses about the application fee or license fees or maybe corollary in statute?
Thank you, Senator McQuaid. Do you proceed?
Madam Chair, Senator McQuaid, the fee that the board is proposing is a $225 fee.
Thank you. Senator Barr?
Thank you, Madam Chair. Mr. Sands with a D, without a D?
Like the sands of a beach, yes.
Okay, thank you. I'm a little confused. So when you mentioned to Senator Drazkowski that the board's not going to get any more authority than what you already have, and now we're requesting a license because, as Senator Kupec mentioned, if you come from North Dakota where they're regulated and they come here, you can hang out a shingle. I'm just a little confused. Can you kind of, why do we need this if you're not getting any more authority?
So, and I will step in if that's okay. Part of the reason the bill is in this committee is because there would be a council created, the Behavioral Analysis Advisory Council, and because this would authorize the board to adopt rules related to supervision requirements for licensed behavioral analysis and assistant behavioral analysis. With that, Senator Kupec?
Sure. Thanks, Senator Mitchell. Senator Barr, we in Health and Human Services, we have heard a whole bunch of groups that themselves have wanted to come forward and have some regulation put on them. So including the behavioral analysts, they've come forward and said, in some ways it's about the integrity of their profession and protecting their profession. And so they've come forward and asked for this licensure to be there so that, they can basically protect the integrity of their field.
Thank you, Senator Kupec. Mr. Sands, do you have anything to add?
Madam Chair, Senator Barr, I would just say that to the point of the scope of authority that the board generally has, it's not adding any new powers that we didn't have for psychology, right? So it's all like the rulemaking, the board meetings, those sorts of things are all in line with what the agency already does. It is adding an existing, a new license type. So there are additional people that we would be overseeing that license.
Thank you. Senator Anderson.
Thank you, Madam Chair. Mr. Sands, how many people are involved with this profession?
Mr. Sands.
Madam Chair, Senator Anderson, my understanding is that there are about roughly 400 behavior analysts that would be involved in this profession.
So, Madam Chair, Mr. Sands, you're saying
Anderson.
that these 400 people are asking for the opportunity to give guidance to how this operation is run? It says here, it may adopt rules necessary for the advisory council. Am I misreading that or not?
Mr.
It's under
Sands.
rulemaking.
Senator Anderson, would you
Page 3, rulemaking says may adopt rules.
Mr. Sands.
Madam Chair, Senator Anderson, that is actually in reference to the Board of Psychology. So the Board of Psychology would be would have the authority to make rules in this profession, much like it does for the practice of psychology in the state.
So, Madam Chair, Mr. Sands, you mentioned that the Board of Psychology will be able to do that. What about the members that you mentioned, like 400 or something? Do they have any say in this rulemaking process also for the board?
Mr. Sands.
Madam Chair, Senator Anderson. The answer to that is yes, they would through the public comment period. They would be able to give comments just like any member of the public would be to any rules that the board looks to adopt. And in addition, there is an advisory council where members of the behavior analysis profession would be on that advisory council and making recommendations to the board about the rules.
Thank you.
Thank you, Mr. Sands. Senator Drazkowski, did you still have a question?
I do, Madam Chair, thank you. So, Mr. Sands, it sounds like about 400 people in this profession, and I did hear you say that, well, and the bill says you're going to now have authority to say yes or no to their license. Is that right?
Mr. Sands.
Madam Chair, Senator Drazkowski, the board will be able to approve licensing based on the statutes that are being looked at here.
Thank you.
So, Madam Chair, Mr. Sands, will you say no to people?
Mr. Sands.
Madam Chair, Senator Drazkowski, if somebody applies that doesn't meet the requirements outlined in statute, then the board would be statutorily obligated to say no to that individual.
Thank you, Mr. Sands.
So, Madam Chair,
Senator Drazkowski.
and Mr. Sands and members, there you have it, additional authority given to the government. I'm curious, and Senator Kupec, I did hear you say that, and I've been around here, that's how it works. There's a group of people that get together within a particular profession. They develop licensure requirements. It's called fencing, Senator, and what that means is that group of people within that profession come together and they put their elbows out and they say, this is what it takes for you to get here. I'm already here as a business, and if you're going to get in, you got to do this. And that's what we're saying in the bill here, and we do that over and over again. Senator Kupec, how many of the 400 people came to you and asked you for this bill?
Senator Kupec.
Sure. Well, I would say, Senator Drazkowski, I had constituents who brought this forward and then also talked with the Board of Psychology. I would also say that this isn't just a regular business. I think it is the business of the state to regulate people that are dealing with minors, vulnerable adults, and particularly around the area of mental health. I think there has to be something out. This isn't necessarily like just me starting a company to go forecast the weather for people. It's a totally different thing. So I think, when we're dealing with more sensitive issues, I think the state does have a role in licensing.
And if I may, to your point, Senator Kupec, both you and I are certified as meteorologists by the American Meteorological Society, which means people of a certain education level are giving that what can be critical data and severe weather events and life-saving things, and to make sure that people actually have the education and the credentials. And to me, I would see this as a similar thing, making sure that, people have that education and credential level. So thank you for your answer.
Well, Madam Chair.
Senator Drazkowski.
Thank you, and thank you, Senator Kupec. They will be coming forward next to credential and licensed meteorologists, or maybe that's already required. Because, of course, people could step out in the rain and end up in a flood and get washed away. That could happen too, Madam Chair. But the reality is a small number of the 400 people that are going to be impacted by this bill and are going to be forced to come and genuflect before the government in order for them to run their business, a small portion of them came to the legislature, to ostensibly the bill author, and said, we want to have licensure. And so we have a bill before us that is going to be favorable to that group of people and people who want to start up a company in the future, who want to start up a a business of this sort will then have a higher bar to entry into the business. It'll cost them more. They'll have to probably do more training. There's probably some CEUs that are going to come next, and a bunch of other requirements that'll be in next year's bill, Senator Kupec, after this is passed into law. That's how it works around this place. And we're building another piece of government to make it harder and harder for the hardworking, overtaxed, overregulated people of Minnesota to be able to operate. And I can see why people are leaving this state, members. They're leaving here for places that aren't doing these types of things to them, where they can actually operate their business without having to beg to the government to be able to operate it. Thank you, Madam Chair.
Senator Cran.
Thank you, Madam Chair. And to follow up on that, so Senator Kupec and Mr. Sands, how long have behavior analysts operated in the state of Minnesota?
Mr. Sands.
Madam Chair, Senator Cran, I'm not actually aware of that. I don't know the answer to that for how long people have operated in Minnesota.
Madam Chair?
Senator Cran.
More than 10 years?
Mr. Sands.
Madam Chair, Senator Cran, I believe that the profession has been around for that long, yes.
Madam Chair?
Senator Cran.
So with that, can you describe or point to harm or injury which has occurred regardless of the longevity of this profession that's been operating, it appears without harm or injury to anybody? I know you described the scenario in which somebody could hop over the border, but where has the injury or harm occurred in those scenarios to justify now licensure? And I'm with Senator Drazkowski. We've seen so many come here and say, well, we've asked for it. Well, those that ask for it typically regret it. And so what's the problem we're trying to solve, and where's the injury been had?
Mr. Sands.
Madam Chair, Senator Cran, what I can tell you is that in the 37 states as of right now do regulate the behavior analysis profession as licensure. Currently in Minnesota, we have what is a certifying body that if somebody chooses to become a member of that certifying body, they will go get that certification. The certifying body doesn't have the authority to really take discipline against people who don't join, or even really they're not well found if people are searching for them to report complaints. What I can say is, in doing my due diligence for this profession, I've looked at other states that have licensure and what kind of disciplinary actions they're taking. And those type of disciplinary actions are based on exploitation of clients, either financially or sometimes physically exploitation, bad treatment records, poor billing procedures, fraud. Those are the types of public harms we're looking at. And with respect to the certification piece of it, when you look at those states that have licensing, the certifying body and those for those licensees in that state tend to have more robust disciplinary actions. And so it strikes me that potentially at least Minnesota's practitioners are also engaged in some of these behaviors, but there's no mechanism for the clients to get relief.
Madam Chair, just
Thank you, Mr. Sands.
Just a quick follow-up, thank you. And so you just described exploitation, billing, and fraud. So there was no other vehicle through the criminal justice system to report a crime against a person outside of going after someone's licensure or industry position?
Mr. Sands.
Madam Chair, Senator Cran, I think what I was trying to say is that they might not be aware of those remedies, or those remedies might not be financially available to them to file in court, because that does cost money. Thank you.
Thank you, Mr. Sands.
Thank you, Mr. Sands.
Seeing no further comments, Senate File 3523 is laid over for possible inclusion. Thank you, Senator Kupec. Thank you, Mr. Sands. Up next, we will go back to Senate File 3428. Senator McEwen, if you could please step forward at your convenience.
Good afternoon.
And Senator McEwen, would you like us to do the A5 amendment first?
Madam Chair, yes, if that is acceptable to yourself, this is a delete all amendment and gets the bill in the shape that I'd like it to be for our discussion today.
Thank you. So we have the A5 amendment, and Senator Gustafson moves the A5 amendment.
Madam Chair, this amendment this isn't the committee of origin, it's re-referral from labor. And so I think it would be incumbent, this isn't an author's amendment, so I think it'd be incumbent to at least describe and walk through the bill, since it's a delete everything, which we just received, before a vote is taken. This isn't an author's amendment nor a first step.
Senator Coran, it looks like Senator McEwen is willing to do that. Of course, the discussion, once we have the amendment, would be the bill as it would be in shape. But Senator McEwen, can you give us a quick description?
Yes, thank you, Madam Chair. I'm happy to go through ahead and walk through the delete all, the bill as we anticipate it to be amended, and then to have discussion on the bill in the form we'd like it to be in. So most of this bill before the committee today is technical, clarifying and improving our bill from last year now that we have seen it implemented, taking care of some technical changes. Section 1 is an amendment to Section 13.43. This will clarify that public employers may not invoke the civil investigative data exception to avoid providing personal data otherwise authorized under Section 13.43. Section 2 restores one limitation to the definition of public employee that will exclude substitute teachers in a school district who are not serving as long-term substitutes. Section 3 amends the definition of teacher to clarify that pre-kindergarten teachers as a group may remain in a wall-to-wall bargaining unit that includes non-teachers in the absence of a unit clarification change. Section 4. Let's see here. Okay. Section 4 has to do with some changes to the Public Employee Relations Board, as well as Section 5 also clarifying when open meeting laws apply and some exceptions to that. Section 6 is a technical change, correcting some language and improving on it. Section 7 ensures that an exclusive representative will be notified when an employee leaves the bargaining unit and the reason for leaving, including employment ending, retirement, transfer, promotion, etc. Section 8 on page 7 of the A5 provides clarification about the logistics of new employee orientation, including when an employer does not plan to conduct group orientations for new employees. It also clarifies who may attend meetings with the exclusive representative. Section 9 updates language regarding modification of units and removal, modification of units. Section 10 requires that a determination of whether a new employment position should be included in an existing bargaining unit be made based on analysis of assigned duties and without regard to title or telework status. Section 11 makes non-substantive technical changes. Section 12 eliminates a requirement that an organization's claim of majority status in support of a petition for certification as an exclusive representative be supported by dated representative authorization signatures. It eliminates a requirement that the commissioner investigate a petition asserting that a majority wishes to be represented by the petitioner. The investigation requirement is also moved to Minnesota Statute Section 179A.12 subdivision 5 in the next section of the bill, and it also makes non-substantive technical changes. Section 13 adds majority verification petitions to requests for elections as conditions that precipitate a requirement for the commissioner to investigate sufficiency of evidence for a question of representation and to hold hearings to determine an appropriate unit and on related matters. Section 14 makes non-substantive technical changes, as does Section 15. Section 16 changes the deadline for the board to hold a hearing on a complaint of an unfair labor practice. Under current law, the hearing must be held not less than 5 days and not more than 20 days after the complaint is served. This section changes that to not more than 30 days after serving the complaint unless the parties mutually agree to a later hearing. Section 17 makes it clear that a refusal to provide relevant bargaining information as well as the refusal to restore an incorrectly removed bargaining unit position is an unfair labor practice. Section 18 makes modification to the Hennepin healthcare units to reflect difference between physicians and interns, residents and fellows. And Section 19 aligns the contract ratification process for home healthcare workers to other state contracts. Just a quick second here. Section 20 authorizes the commissioner of the Bureau of Mediation Services to adopt rules on petitions for majority verification using the expedited rulemaking procedure. And Section 21 instructs the reviser of statutes to renumber current subdivision 3 as subdivision 1A in Section 179A.12. So, Madam Chair, that is a quick overview walkthrough of the bill. I do have the Commissioner of the Bureau of Mediation Services here, as well as the Executive Director of the Public Employee Relations Board and advocates here in support of some of these changes. This has been a collaborative effort amongst agencies and also the people who are involved in this work, just to really fine-tune the work that we did last year to make sure that it works in the best way possible and to make some little adjustments here and there. Ask for your support.
Thank you, Senator McEwen. Seeing no further discussion on the amendment portion, Senator Gustafson moves that the A5 amendment be adopted.
Madam Chair, roll call.
A roll call has been requested. A roll call will be granted. Please take the roll.
Chair Mitchell.
Aye.
Chair Dietzick.
Aye.
Senator Anderson.
No.
Senator Barr.
No.
Senator Carlson.
Aye.
Senator Swedzinski. Senator Drazkowski. Senator Fateh.
Aye.
Senator Gustafson.
Aye.
Senator Jasinski. Senator Coran.
No.
Senator Lang. Was that a no?
That's a no.
Senator McQuaid.
Aye.
Senator Morrison.
Aye.
Senator Swedzinski.
Yes.
Thank you.
There being 8 yes votes and 4 no votes, the motion prevails. The amendment is adopted. Senator McEwen, you did a pretty thorough walkthrough already. Did you have any other comments?
I do not have any additional comments at this time, Madam Chair.
Thank you. Seeing nothing further from Senator Anderson?
Thank you, Madam Chair. Looking at the bill, the original bill, we have 9 pages with rulemaking, expedited rulemaking process, and then we jump into a new delete all amendment that has the same expedited rulemaking process, which means that most likely the public will not have any type of input into what and how these rulemaking procedures or process will be adopted. So, Madam Chair, I have the A6 amendment.
Senator Anderson has offered the A6 amendment. Senator Anderson, could you please describe your amendment while it is getting passed around, including to make sure the author gets a copy?
Thank you, Madam Chair. Page 18, delete Section 20 and insert Section 20, a report. The Commissioner of Bureau of Mediation Services must report by November 1st, 2024, to the chairs and ranking minority members of the committees in the House of Representatives and the Senate with primary jurisdiction over the Public Labor Relations Employment Act, with recommendations for a process to verify a majority support for a petition under Minnesota Statute Section 179A-12, that recommendations must include draft legislation to implement the recommendations, including technical changes required for consistency with Minnesota Statute Section 179A.12. And that basically is just asking for a report to come back to us rather than a rulemaking process in the statute as amended, or in 348028 as amended.
Thank you, Senator
And I'd
Anderson.
like a roll call, please.
A roll call has been requested. Senator McEwen.
Thank you, Madam Chair, and thank you for the discussion on the A6 amendment. As I noted, I do have the Commissioner of the Bureau of Mediation Services here. I'd like him to have an opportunity to address the committee about the request on the expedited rulemaking in this particular bill. I know this has been a hot topic of conversation this afternoon in this particular committee, but in regard to this bill in particular, I'd like the Commissioner to be able to have some input into the allegations that were made about the public being left out of that. Thank you.
Thank you. Mr. Commissioner, if you could please state your name and title for the record and then proceed.
Madam Chair, Senators, my name is Johnny Villarreal, Commissioner of the Bureau of Mediation Services. With regards to the rulemaking process for this particular bill, it is limited to the majority verification piece, and that is all. About 3 years ago, the Bureau did an update of our rules under previous Commissioner Jan Johnson, and under that process, we went through the full rulemaking process, and no hearing was required at that point. We did get citizen input, and my understanding under the expedited is that citizen input is still something that occurs as far as the process, with the exception of the hearing portion. But the expedited rulemaking process, again, is limited to just the majority verification, and we see that as a technical update only, not substantive.
Thank you. Senator McEwen.
Thank you. With that, because of the limited nature of this particular expedited rulemaking and the technical nature of it, I am not in support of adding the A6 amendment at this time. I certainly welcome discussion. This is, of course, the first time I have seen this A6 amendment, and I'm happy to entertain discussion as we move forward. My office is always open to that, but as of today, I would ask that members do not adopt the A6. Thank you.
Thank you for your commitment to continue these discussions.
Madam Chair.
Senator Anderson.
This is the first time we've seen this amendment, too, on this particular bill as far as the delete all. So to say you haven't seen my amendment, I haven't seen your amendment either.
Seeing no further discussion on the A6 amendment, Senator Anderson moves the A6 amendment, and if you could please take the roll.
Chair Mitchell.
No.
Chair Dietzick.
No.
Senator Anderson.
Yes.
Senator Barr.
Aye.
Senator Carlson.
No.
Senator Swedzinski.
No.
Senator Drazkowski. Senator Fateh.
No.
Senator Gustafson.
No.
Senator Jasinski. Senator Coran,
No.
Senator Lang,
Madam Chair, sorry, yes. I was asleep at the wheel.
Just for future reference, we are not supposed to stop a roll call.
Senator Lang, Senator McEwen,
No.
Senator Morrison.
No. There being 4 yes votes and 8 no votes, the motion does not prevail. I'd also like to mention that the delete everything was posted yesterday for review, so.
Madam Chair,
For the
that was at
committee.
8:50 last night.
So Senator Anderson, you just said that you had not seen it, and now you know what time it was posted.
I do know what time it was posted, but I
Okay.
get to see the amendment at that time. I was home trying to get some sleep.
Thank you, Senator Anderson.
Madam Chair,
Senator Coran.
I would like to move the A7 amendment.
The A7 amendment has been offered. If that could be, please be passed around, including to the author. And Senator Coran, if you can please describe that while that is happening.
Thank you, Madam Chair. So what the A7 does, Senator Anderson had the A6, which removed the rulemaking, included reporting. This is a good compromise. What this does is it keeps the rulemaking, but requires the department to submit a report to the legislature next year after the rules are implemented, and puts the rules, before it puts the rules into statute and to repeal rulemaking. Really is a report to the legislature to understand what the true need is and provide a report to justify it. Justify moving and continuing rulemaking. Thank you, Madam Chair. I encourage a yes vote, and I request a roll call.
A roll call has been requested. A roll call will be granted. Thank you, Senator Coran. Senator McEwen, have you had an opportunity to see this, and do you have any feedback?
I am just looking at it right now. It is sort of interesting to be sort of have these amendments brought forward and not have been approached about them at all. I think that it is curious to me to sort of not like the rulemaking process, and then because of that to ask for the state government to perform a whole bunch of more work to try to go after the rulemaking process. But again, I would say that I'm always open to entertaining some thoughtful measures, some thoughtful discussion that would lead to policy changes that would improve the policy framework that we're working under. And if it turns out that it would be a best practice to do something like this, then I'm all ears. My office is open. Come talk to me. We can talk about making this change. On the fly like this in committee, I'm not comfortable making that change without having vetted it with the commissioners, with the agencies, with all of the people who are involved in this work and have contributed to the content of the bill as it is now. So that said, respectfully, thank you for the discussion. Thank you for the introduction of the A7. At this time, I would ask that members not adopt it.
Thank you, Senator McEwen. Seeing no further comment, Senator Coran has moved the A7 amendment. Can you please conduct the roll?
Chair Mitchell,
No.
Chair Dietzick,
No.
Senator Anderson,
Yes.
Senator Barr,
Aye?
Senator Carlson,
No.
Senator Swedzinski,
No.
Senator Drazkowski, Senator Fateh,
No.
Senator Gustafson, Senator Jasinski, Senator Coran,
Yes.
Senator Lang, Senator McQuaid,
No.
Senator Morrison.
No. There being 4 yes votes and 7 no votes, the motion does not prevail. Seeing no further discussion on Senate File 3428, the Senator Morrison moves that Senate File 3428 as amended be passed and referred to the Finance Committee.
I believe so. Thank you.
Madam Chair, roll call, please.
A roll call has been requested. Can you please take the roll?
Chair Mitchell,
Yes.
Chair Dietzick,
Yes.
Senator Anderson,
No.
Senator Barr,
Nope.
Senator Carlson,
Yes.
Senator Swedzinski.
Yep.
Senator Drazkowski, Senator Fateh,
Yes.
Senator Gustafson, Senator Jazinski, Senator Coran,
No.
Senator Lang, Senator McEwen, Senator Morrison,
Yes.
Senator McEwen,
Aye.
There being 7 yes votes and 4 no votes, the motion prevails, and Senate File 3428, as amended, is passed and referred to the Finance Committee. Thank you, Senator McEwen.
Thank you very much, Madam Chair. And again, I would like to extend an invitation to those people who brought amendments. If indeed those discussions, desire to have those discussions is sincere, I look forward to talking with you further about them. Thank you.
Thank you. And Senator McEwen, I believe you also have Senate File 4165.
Yes, I do.
If you could, once you're ready, proceed.
Thank you, Madam Chair, members, today for hearing Senate File 4165. The DNR must maintain clear rulemaking authority to keep the shoreland and waters of the state rules current, relevant, and reasonable for effective program administration. Without it, the DNR is unable to do simple housekeeping to clean up obsolete, unnecessary, and duplicative rules provisions as required of all agencies, and to amend the rules to reflect statutory changes that supersede rules or other changes that don't alter the sense, meaning, or effect of rules. Though the DNR has no current plans to do so, the agency is not able to update the rules to address contemporary development issues without clear rulemaking authority. This proposal would amend Minnesota Statute 103F.211 Subdivision 1 and 103G.315 Subdivision 15, and those are the Shoreland Management Act and the Water Law, Public Waters Permits and Use, to clarify that the time limit on authority to adopt, amend, or repeal rules associated with laws authorizing or requiring such rules would not apply to DNR's standing general rule authorities for Minnesota's Water Law and Shoreland Management Act. In doing so, it affirms DNR's standing rulemaking authority to originally granted by the legislature for these programs. Importantly, this proposal would not provide the DNR with any new or expanded authority, nor would it direct or require any rulemaking activity by DNR. This really is a measure just to make sure that there's clarity in the laws and the authority and no confusion. And with that, I do have a expert testifier here in support from the DNR to be able to speak to the need for this bill as well.
Thank you, Senator McEwen. Our testifier, Melissa Kuski, can you please identify yourself for the record and continue with your testimony?
Mr. Chair, committee members, my name is Melissa Kuski, and I'm the Deputy Director of DNR's Ecological and Water Resources Division. I'd like to thank you for the opportunity to testify today on Senate File 4165. This is an agency policy bill, and I want to thank Senator McEwen for authoring it. The bill helps to reaffirm DNR's standing general authorities to conduct rulemaking for shorelands and waters of the state. Senator McEwen provided an overview of the bill and its intent, so I'll keep my remarks as brief as possible and just note that this proposal is a proactive effort on DNR's part to reaffirm and ensure our standing general rulemaking authorities. At this time, the DNR is not planning any shoreland or waters of the state rulemaking activity in either Chapter 103F or 103G. However, if and when a need for rulemaking arises, whether it's a simple housekeeping action to clean up or repeal obsolete, unnecessary, and duplicative rule provisions, or a more substantive effort to keep shoreland and waters of the state rules current and relevant to today's environmental and regulatory needs, it is important that DNR have clear authority to do so. Addressing these rulemaking authorities before a rulemaking need arises helps to ensure that we can be efficient and timely for any potential future efforts when they begin. Thank you again for the opportunity to testify. I'm available to stand for questions.
Thank you, Ms. Kuski. Do we have any amendments? No amendments? Questions and comments from the members?
Mr. Chair.
Senator Cran.
Thank you, Mr. Chair. And Senator McEwen, in the testifier just said that there is no immediate need. So I get two questions, and I understand you described that there is no immediate need, but you also want to be able to act and move forward. But the authority, it implies in the statute to adopt model standards and criteria. Create new standards would be more accurate, right? Because you're not adopting everything we do here, right? We're adopting something typically from some federal law or some other standards. This is our standards or guidelines that you're looking to create or have an open view of rulemaking in case need is determined at a future date. Is that a correct statement or an accurate description?
Senator McEwen.
Madam Chair, thank you, Senator Cran, for the question. My understanding is that uncertainty about the DNR's rulemaking authority developed after the legislature directed the DNR to update the statewide rules pertaining to shorelands and structures in public waters. So that the legislative direction from that may have triggered a deadline under one of our statutes, which requires publishing a notice of intent to adopt rules, and due to the complexity, the DNR was unable to meet a 18-month deadline. What this legislation does, from what I understand it, is just clarify the previous legislative intent was not to hamstring the agency in that rulemaking authority. It was actually to allow them to go and do their jobs. But I will go ahead and defer to our expert here for any further clarification on the need for this.
Ms. Kuski, please.
Madam Chair, Senator Cran. Senator McEwen, I think, did explain generally. You're right, though, that these rules are part of our state requirements. However, even under those even as state rules and not necessarily conforming federally, there are often needs to address and clean up obsolete or duplicative rulemaking if there are certain methods of development as may pertain to the shoreline standards that are no longer relevant, and those portions of rules may no longer be needed. Being able to do a rule cleanup under our standing general authorities is helpful and good governance for us.
Thank you.
Thank you.
Madam Chair. So I think, Senator McEwen, you did describe it, that, yes, it had a sunset of rulemaking. And so that's the reason the legislature meets every year, and to determine and make sure that we play a role in granting the authority. Today, it looks like you're granting an unlimited, removing the time frame for that type of rulemaking to make those shoreline policies or whatever they are without any legislative oversight. And so if it was a process that was as transparent as rulemaking or lawmaking, where citizens have an opportunity to participate, then maybe we would feel better about it. But rulemaking, in this case now, you're removing the deadline, and then when some of those impacts are so significant, maybe necessary from an environmental perspective, that we would agree on, but that's the role of the legislature. To me, it's another piece where you're looking to remove the rulemaking or removing legislative oversight for some of those issues that may rise and should rise to the legislature for oversight. Again, I think there's opportunity through the rulemaking process to make it more transparent so citizens can track those things, but they typically are driven by a bill or an action or a need. In this case, is while we may have a need, and there's no way for real notification or somebody to track it if they're a concerned individual or a concerned citizen. So I'm against having unlimited rulemaking without timeframes and clear direction, because it removes the public and the opportunity to participate in the transparency. So I don't support this bill. Thank you.
Thank you, Senator Coran. Seeing no other questions or comments, Senate File 4165 is laid over for possible inclusion.
Thank you very much.
Next up, we will be, again, we are changing the order some today because we have different members testifying in different committees. So up next, we will go to Senate File 3611, which is Senator Mann. And Senator Mann, when you get comfortable, you can please proceed.
Thank you, Madam Chair. Members. So Senate File 3611 is a bill to change how we license internationally practicing physicians. So right now, if you are a practicing physician in another country, and you could have been practicing for 20 years, when you arrive in Minnesota, you are not allowed to practice medicine again until you have, 1, passed all of your step exams, and there are 3 of these used to assess your medical knowledge. 2, you have gone through residency all over again. Residency is a 3 to 7 year training that physicians go through after medical school. So having to do residency all over again is not only unnecessary training that physicians have already done, but it is a barrier to getting qualified, competent doctors back out into the field. And it may sound like it's not a big deal until I tell you that we don't have enough residency slots for American graduates. So we are preventing people from practicing medicine because there are no residency slots, and not because they don't already know how to practice medicine. It's estimated that there's about 220 to 300 physicians ready to practice medicine in Minnesota, but can't because of the current requirements. So what this bill does is remove the residency requirement, and it replaces it with other requirements. So an experiencing practicing medical doctor would be eligible to practice in Minnesota if they have graduated from medical school, they've been practicing in their country for at least 5 years, they come and they pass all 3 step exams to assess their medical knowledge, and they practice in Minnesota in a rural or underserved area under the supervision of another physician for 2 years. If all these requirements are met, then they will receive a license to practice medicine. And this will do 3 things. 1, it'll diversify our workforce. 2, it's going to increase the numbers of doctors practicing medicine. We currently have a physician shortage, which is only getting worse, and will increase, and this will also increase the number of doctors practicing in rural areas. And then 3, it'll open up residency slots that are necessary for newly graduated physicians. We are not the first state to do this. And with that, Madam Chair, I do believe there's a testifier.
Thank you, Senator Mann. And I also understand you have the A2 amendment. Would you like to testify first?
We can adopt the amendment, Madam Chair. It's just changing the effective date.
Thank you. Senator Morrison moves the A2 amendment. Does everyone have a copy of that? Yes, okay. I am hearing everyone has a copy of the A2 amendment, as Senator Mann said, changing the effective date. All in favor, please say aye. Aye. Opposed, nay. The motion prevails. Senate File 3611 as amended. Please proceed with our testifiers. Dr. Eltrafi, if you could please properly say your name and title for the record.
Thank you so much. Thank you, Madam Chair, Mitchell, and committee. My name is Sarah Eltrafi. I'm a physician from Sudan. I graduated from the top university in Sudan, Khartoum University, medicine. And after that, I worked in rural hospitals, in community hospitals, in both Sudan and Saudi Arabia. After that, I was recruited by the leading research hospital in Saudi Arabia, the National Guard Hospital, as a clinical research coordinator. During my stay in Saudi Arabia, my father was convincing me to come here to the U.S. to pursue my education and to finish my training, because it is the land of medical innovations, and it is the place to get the best training possible. Unfortunately, after moving here, this has not been the case for my journey so far. I moved to Minnesota in 2013 to pursue my career and advance my skills. Minnesota has been very welcoming and safe home for me and my family. I found in it a home where my children and I can prosper. However, relicensing in the U.S. has been one of the toughest journeys of my career. Similar to all medical graduates, I went through the exams and residency applications with the hope that at the end I would be able to finish and continue my practice here as well. I have spent tiring hours applying for residencies, but to no avail. This not only took away 11 years of my ability to practice medicine, but also had a massive impact on me financially. Having such a bill in place 11 years ago would have made a big difference in my life, as I would have been a full practicing physician by now here. This bill will eliminate the wait to get into residency and will create more needed positions, as many international providers like me apply for many years in a row without getting accepted. When I applied for residency, I thought I had good chance of getting into programs given the huge physician shortages, as well as my qualifications. Unfortunately, I still got rejected. The underserved areas and rural areas of Minnesota are where healthcare is most needed. It would be incredible to create healthy communities there and a state of well-being and prosperity. I have come from a place where I have seen people suffer from not having access to health care. That is the main reason why I am here before you today. My case is similar to so many international graduates. It's a huge waste of potential, an incredible loss of assets, and the loss of Minnesota's healthcare system and the U.S. in general. Having such a bill will be a step in the right direction to rectify this. I am truly grateful I was given this opportunity to speak in front of you today, and I would finally like to emphasize the importance and benefit of such a bill and the positive impact it can have in Minnesota's different communities. I hope you will support this bill, not only to help other immigrant providers like me, but to ensure the prosperity of healthcare in Minnesota. Your patience and listening to me is much appreciated. Thank you.
Thank you, Doctor. Senator Mann, if I may ask a question before I open it up to everyone else. What I've heard in the mental health field and some of the other medical fields is that in addition to a shortage, we also have a shortage of providers that speak different languages and might have different cultural competencies. Would this help make our portfolio, so to speak, in Minnesota more robust in those areas?
Thank you, Madam Chair, for that question. Absolutely. So we also know that healthcare outcome is directly tied to essentially cultural competency. We have several studies showing that healthcare outcome is tied to the relationship between you and your doctor, right? And we know that when your doctor and you look alike, care is actually better. So that will help all those things.
Thank you so much, Senator Mann. Any other member questions? Senator McEwen.
Thank you, Madam Chair. Senator Mann, I sent an email because I want to join your bill, and I think I told you this story, but when I was in college, it was my 21st birthday, I got in the cab to go back to my university, and I was talking to the cab driver, and I said, where are you from? And he said he was from Sudan, and I said, what do you do? And he said, I'm a neurosurgeon. And I was like, why is a neurosurgeon driving me back to my dorm when I'm 21 years old? And that has stuck with me. I think about him all the time. And I asked him, what was it like? And he said, oh, the same as it would be here. Brains look the same. And so I'm so glad you brought this bill. This is so important. And I really hope that neurosurgeon is still here in Minnesota. I hope he's practicing, because I genuinely think about him all of the time. It's something that we can do something about. So thank you for your bill.
Thank you, Senator McEwen. Senator Morrison.
Thank you, Madam Chair. Just very briefly, Dr. Mann, thank you. Pleasure to hear this bill again. Thank you for testifying again. Your testimony is very important. This is low-hanging fruit. This is something we should have done a long time ago. It's no accident that the three physicians in the Senate are all co-authors of the bill. I hope that we can get bipartisan support. This would be a wonderful improvement for Minnesota.
Thank you, Senator Morrison. Seeing no other discussion, Senate File 3611, as amended, is laid over for possible inclusion. Thank you. Thank you. And Senator Mann, if you could please stay with us. Senate File 4461 is next. And please start presenting when you're ready.
Thank you, Madam Chair. Senate Files 4461 makes changes to open meeting laws. So COVID taught us many things. One of those things is that those participating in virtual meetings can get just as much things done as those in-person meetings. Virtual meetings make it easier for women and for people with disabilities to participate in their communities. And members, you should all have a letter from the Council on Disability on their support of this bill. Virtual meetings are already allowed. All that Senate File 4461 does is to erase language that made it unsafe for people to attend virtually. And it changes the notice requirements so that people aren't prevented from participating based on a technicality. So for example, right now, if you are participating from home because you're taking care of your sick spouse, your home by law has to be open and accessible to the public. So your door has to be open and people have to have access to you inside your own home. And right now, if your babysitter that you planned on gets ill and can't come, you also can't go to your meeting virtually because there has to be a 3-day notice requirement that you're attending virtually. So in the era of unaffordable childcare, this will disproportionately, of course, impact women and prevent them from participating in their communities and local government. So that's really it. It's a very simple bill, updates outdated language because our laws have not kept up with our technology. With that, Madam Chair, I do have an amendment, author's amendment.
Thank you. And this is the first stop of this committee. There is an A1 amendment. Everyone should have that in their packets. And Senator Morrison offers the A1 amendment. All in favor of the A1 amendment, please say aye.
Aye.
Aye. Opposed, nay. The amendment is adopted. Senator Mann, should I proceed to your testifier?
Please, yeah.
Thank you. Our testifier is Ms. Oxnavad. If I didn't say that correctly, please state your name and title for the record.
Thank you, Chairperson Mitchell and committee members. My name is Laura Oxnavad. I'm a school board member, and I'm honored to testify on behalf of the St. Anthony New Brighton School Board, Association of Metro School Districts, and the Minnesota School Boards Association in support of Senate File 4461. With the advent of online streaming and remote access, a beneficial lesson from the pandemic, school boards across the country have been able to better project their meetings to the public. No longer are school boards in their communities limited to in-person access. When unpredictable events arise due to illness, childcare, unforeseen transportation issues, work emergencies, and more, school board members should be able to connect to meetings via remote access. Here are a couple recent examples of when our board navigated the current statute, which limited our ability to do the business of the school board. In December, our school board chair tested positive for COVID with mild symptoms on the day of our regular meeting. He conferred with Terry Morrow of MSBA, but because his location was not posted 3 days in advance, he was unable to participate remotely in the meeting. If this restriction were lifted, he would have been able to not only participate, but he could have led the meeting. His valuable leadership, knowledge, and perspective were unnecessarily missed. In February, our newest board member's child became ill on the day of the school board meeting, and she was thus unable to attend. While she was able to view the meeting remotely, she could not participate. Her valuable knowledge and perspective were unnecessarily missed. This bill maintains transparency to the public while adapting to new technology. I believe it's important that our school boards reflect our communities, and this updated language allows all persons interested in serving to participate in meetings even when unpredictable events arise. Senate File 4461 provides equitable accessibility not only to the viewing public, but also to school board members. Thank you, Senator Mann, for carrying this bill, and thank you for the opportunity to share our story.
Thank you for your testimony. Do we have any questions or comments from the committee? Senator Cran.
Madam Chair, Senator Mann, so it looks like in this, I think when this was put in place, again, to honor kind of the public exposure, right? And I think that came with accountability. I agree with the issue in somebody's home, right? You know, and a one-off or an emergency purpose that the timelines didn't match or didn't work for participation. But what this bill does, though, is it looks like it removes any limits, basic notification, you could be anywhere, and without limit, I have concerns that the reason they were in a public place is there's a level of accountability when you have to participate and vote to the citizens you serve, much like why we shouldn't be having proxy voting here. Voting and serving is more than just voting, and that whole process of accountability, one is being present. And so this doesn't seem to strike any balance, and I think the target that you're looking at, I think I could agree that, yeah, it could be refined, the notice and those things occur. But there was a 3-day section in there, or to say, hey, if you used it more than 3 times in a year, and we had exception for military, I think we could strike a balance. But to give carte blanche to any municipal government that says, yeah, I don't have to show up anymore. I get elected and all I have to do is cast a ballot and participate from somewhere, maybe not in Minnesota. I don't think that's what we want either, because that doesn't best serve the citizens. And yeah, they have an opportunity to unelect them at some point in the future, but what if that's somebody's goal? I've got commissioners in my district that want a snowbird. That's great. You probably shouldn't run for office because you need to serve and be accountable. They got a 4-year term. So I think the original bill was to try and strike some balance and say, guys, there is some limits here. Emergency purposes only. And then after that, there should be some way to draw people there. We shouldn't have to tell people to be there, but what I worry is kind of what we're seeing happen around here is people don't participate. And so I don't support, I think I support the intent, but I can't support having unlimited, no need to show up and just cast a ballot and not be accountable to the citizens. Because the corrective action in that next election cycle can be way off in the distance. So I would hope that you could revise it to something more manageable that does meet the true intent without being unlimited. So thank you.
Senator Mann.
Madam Chair, Senator Cran. So we didn't change that at all. Right now, the law is unlimited. That 3 times only refers to the number of times that the individual can be in a location that isn't open to the public. So if you want to take every single meeting from a Starbucks in Florida that is open to the public, you currently, under the current law, you can do that. So this law doesn't actually change that at all.
Thank you, Senator Mann. Senator McEwen.
Thank you, Madam Chair. And Senator Mann, I have a question for you. So under current law, if I was pregnant with twins and I needed to be on bed rest for 3 months, and I was on the school board in my district, we have meetings twice a month. What is the current law around my ability to participate remotely while on bed rest, pregnant with twins, as a school board member?
Senator Mann.
Madam Chair, Senator McEwen. So right now, you'll be able to participate 3 times when your home is not accessible to the public. Other than that, you can participate the rest of your 3 months, but your door has to be open and people have to have access to you while you're in bed. That's the current law.
Thank you, Senator Mann. Senator Drazkowski.
Thank you, Madam Chair. Well, Senator Mann, that's a false choice. You can go to a public place, and that's an option. We are in this bill creating some perverse incentives, I think, for people to not show up at the meeting place, and I concur with Senator Cran. And much of the discussion, including the testifier here, focused on the interests of the individuals serving in office. And the question is, should that be more important than the interests of the public to be accessible to the people and the elected people that they elected, and the meeting that's happening and the impactful discussions on those decisions? And I think And back to the example of the legislature, for Senator Coran and myself and others that have been saying, you know what? The law says, the Constitution says, the legislature shall meet at the seat of government, and the seat of government is St. Paul. And for those of us that have been advocating going back to that, the discussion has been, well, what about Joe or Jill or whoever over here, and if this happens to them, if they're sick, if they have a baby? That has happened throughout our history. Since 1858, it's happened over and again. And in that case, for the legislature, Senator Mann, you have the ability to be absent. Should we, at that point, force participation of those people who might be sick or whatever? Instead, they can simply be absent. And that's part of the process. That's part of the understood and long-held approach to the process that provides a particular product. And I see this bill as very parallel to that. We are trying so hard to accommodate the individual on the school board or the individual on the city council. They could be in Tanzania under this bill and participating in the meeting without the ability, certainly, of their constituents in Inver Grove Heights or in Mora to be able to participate and look them in the eye and see them firsthand. And so I agree with Senator Coran. I think this pushes, in the effort to accommodate the individual, we are ignoring and running away from our responsibility for the public. And that's our first and utmost responsibility is to the people of the state, not the accommodation of the individuals in elected office. And I think that's where this one goes awry. And as I mentioned, is a perfect parallel to the discussion we're having in the legislature. Thank you, Madam Chair, Senator Mann.
Thank you, Senator Drazkowski. Senator Mann?
Yeah, thank you, Madam Chair. So first, I don't think it is a false choice, right? Because in Senator McQuaid's example, she was in bed rest. So it's not like she can go to Starbucks while she's in bed rest. Also, say I have a toddler, my babysitter doesn't show up. I cannot take my toddler to a public place because I have to watch that toddler and I can't participate in the meeting. I can let my toddler run around my house, though, and participate in the meeting just fine. And you're right, this has happened throughout our history, where people can't participate for many reasons, childcare, sickness. But what has also happened throughout history is that women and people with disabilities have been excluded from all of these contexts, right? If your baby gets sick, great, don't show up, we don't care. If you're pregnant, super, don't show up, that's fine, you don't have to participate, we don't need your voice here. That's also happened throughout history, so we're gonna change that. And then it's not forced participation. If you don't want to participate, you can, and I would venture to say that most people who run for school board who get paid pennies on their hour of time aren't participating because they don't want to participate. Like, that makes no sense to me. So I don't quite agree with the idea behind that.
Thank you, Senator Mann. Seeing no further conversation, Senate File 4461, as amended, is laid over for possible inclusion. Thank you, Senator Mann. Up next on the list is Senate File 3691. Senator Hoffman, can you please come to the testifier stand? Oh, look, you're already there. Proceed when you are ready.
We're doing 61 first, right, Madam Chair? Or 91?
I have 3691 first on the list.
Do you? All right.
But
nope. We'll start there. We'll do social workers.
Thank you.
Awesome. So thank you, Madam Chair and members. This first bill in front of you, specifically what you have, there should be an amendment at the desk. Is that correct?
We have an A3 amendment. Would you like to move that first?
I cannot move that, Madam Chair,
you want
but
that
it would
first?
be great if somebody here.
Senator Gustafson moves the A3 amendment.
Thank you, Madam Chair, and I'm going to tell you what that A3 amendment is. When we introduced this bill, there was actually two bills. And this amendment is a compromise between the two bills that dealt with the social work licensure. And what we did is adopting the amendment today. It aligns the language with the other body. I'm not going to say those that are Can I say that? Because, right, Senator Drakowski, you can't say you have to say the other body if you came from that chamber, right? So the other body, it aligns the other body language in there. And then if you look at sections 3 and 4 from Senate File 3691, we removed that because the proposed changes to the amendment is reverted to the original statute language. So it cleans that up. It's technical. And then the following then is the original language. Section 3 reinstates 37.5 hours from the original statute. Section 4 reinstates the 3 hours from the original statute. Then the other thing in that is the additional changes related to recodifying. This is the other thing that had to happen this year. That was brought specifically on the language on 148D and 148E, and that's the provisional license qualifications on the board standard of practice or a licensure pathway for social workers. In that statute, that includes the Board of Social Work and other license pathways, license exam, and licensure by endorsement. So, members, the proposed changes to the social work license statute creates an alternative license pathway without the national exam for social workers. That's the provisional license. And the proposed changes removes the following eligibility criteria that's in front of you as well. In addition, the recodification, and this is why it's in front of you. The specific piece is why it's in front of you. It updates the I can't even say that, disciplinary language for the provisional license. It updates the supervisor eligibility and it expands the methods on the supervisor to align to the current work that the statutory language that you saw the changes 148E have on the social workers. So what it's not changing is the myths out there. The provisional license maintains 2,000 hours of supervised practice and 37.5 hours with a board-approved supervisor. And the provisional license is effective for up to 3 years for the license to complete. That licensee needs to complete the supervised practice and supervision hours. So that also we address the exam pass, the pass rates, the exam pass rates, the disparities, the opportunity for education, those that are struggling to pass the national exam. What you have is Yo Yang from the Board of Social Work, and she's here, and you need to know that there was two groups out there. There was the association and there was the board, and they worked together as we asked them to do in Health and Human Services to get through these issues. That's why it's now in front of you to just say, great job, way to go, and you need to send the bill back to Health and Human Services so we can do what the other body did, was it's sitting in their omnibus bill, Madam Chair. For that, I thank you, and I'd love to have a motion, and I can leave you alone.
Thank you for all of the explanation on the bill and its amendment. We do have a motion to move the A3 amendment. All in favor of the amendment, please say yes. Aye. Opposed, nay. With that, the A3 amendment is adopted. Is there any further conversation on the bill as amended? Seeing no further conversation on the bill, Senate File 3691 as amended, or Senator Swazinski moves Senate File 3691 as amended. All in favor, please say aye. Aye. Opposed, say nay. Senate File 3691 as amended is referred to the Health and Human Services Committee. I apologize, I didn't say that when we were moving it. Senator Hoffman had mentioned it, but that is where it will be going. Thank you so much, Senator Hoffman.
Thank you, Madam Chair and members. You're doing a due diligence by sending it back to our committee. I appreciate that. I think now the other one is Senate File 439, 0439.
Yes, that's a very low number, Senator Hoffman.
You know why it's a low number? Well, Madam Chair and members, here's why. This bill that you are looking at unanimously passed out of this committee, ready multiple times, both in 2022 and 2023. It's a bipartisan bill. Senator Nelson and Senator Rarick were the authors along there, and co-authors now with me this year along with Senator Abler. But here's the thing, the history of this. And I think, when you talk about efficiencies of government, this is where it falls in. Senator Cran, that's supposed to be for you and funny, but I guess I'm not funny. But this bill was included. Remember in 2022, it was carried by Senator David Tomassoni, and Senator Rarick brought it across the finish line. We included it in the conference committee report on higher ed in 2022, right? That bill never got to the floor in 2022, but it did last year, right? We passed this bill on the floor, members, and sent it back to this body because the other chamber, I'm not going to say who they are, but they couldn't figure out the pathways that we had over here. So now we're back this year, hence it's a lower number, Senator Anderson. But what we're doing is we're getting those two staff members that we need to continue the good work. The House is now finally moving it, and I believe, Chair Mitchell, that we need to bring this thing, either we can put it on the floor or send it back someplace else, but it had to come back out of your conference, out of your committee, in order for us to move it again, even though it's passed multiple times.
And Senator Hoffman, I believe the intention would be to place it on general orders coming out of this committee.
Thank you.
So with that said, committee members, are there any questions for Senator Hoffman? Seeing no questions, Senator McQuaid moves that Senate File 439 is recommended to pass and be placed on general orders. All in favor, please say aye. Aye. Opposed, nay. The motion prevails. Senate File 44, I'm so used to these
so
big
small.
numbers, I can't say it. 439 has passed and is placed on general orders. Thank you.
Madam Chair, members, thank you. Next time I'll bring you number 6,020 or something?
That would be easier, I think, for me to say at this point. Okay, up next, we are going to do Senate File 4891, which is Senator Gustafson. Again, we're moving out of order occasionally just because of who has different committees they're testifying in. This is deadline week, so thank you for your flexibility. Senator Gustafson, when you get settled, you can proceed.
Thank you, Madam Chair and committee members. Senate File 4891 makes technical and conforming changes to the Administrative Procedure Act and Office of Administration Hearings provision. It establishes data protection, requires the Chief Administrative Law Judge to appoint a Deputy Chief Judge, authorizes the Chief Administrative Law Judge to appoint a temporary judge that is not the Deputy Chief Judge, and it goes through a couple of other technical changes that we just needed to clean up. There is one testifier and no amendments.
Yes, there's an amendment.
I'm sorry, that's wrong. Madam Chair, there is an amendment.
Senator Gustafson,
Thanks.
It's okay.
this is the first stop for this bill, and Senator Gustafson is offering the A1 amendment. All in favor, please say aye. Aye. Opposed, nay. The A1 is adopted. Senator Gustafson, should I proceed with the testifier now? Thank you.
Yes, thank you, ma'am.
Chief Judge Starr, always lovely to have you. Please state your name and title for the record.
Madam Chair, members of the committee, my name is Jenny Starr, and I'm the state's Chief Administrative Law Judge. I oversee the Office of Administrative Hearings. I was going to walk you through the details of the bill. Is that? Yes.
Yes, please.
Okay. So Article 1 brings data practices standards that apply to our executive branch courts. That's the Office of Administrative Hearings, the Tax Court, and the Workers' Compensation Court of Appeals into conformity with certain data practices standards that apply to the judicial branch. This includes protecting judicial work product and health-related documents and data included in a court file. It also permits a judge to make findings of fact and apply the law to necessary findings of fact to those medical records if it's needed for the purposes of the court's order. With regard to Article 2, court operations, it brings the office into conformity with other executive branch agencies by ensuring that if the person in my role, for any reason, were unable to continue to serve, that there would be a person, the deputy chief judge, who would step into that role, or the person appointed by the governor. It allows, Article 2 allows the Office of Administrative Hearings to contract directly with interpreters who are certified or rostered in the Minnesota Supreme Court program. This ensures access to valuable and skilled interpreters in our court proceedings. And it tolls a particular 90-day period when a motion is being considered by me to extend or not extend that 90-day period. Article 3, rulemaking, requires executive branch agencies, including the Office of Administrative Hearings, to file electronically with one another. It clarifies that certain rulemaking deadlines count working days, and it conforms the obsolete rulemaking process with certain provisions of the expedited rulemaking process, in particular my authority to delegate obsolete rulemaking procedures to an administrative law judge. Article 4 repeals the false literature claim of action that's currently provided by Minnesota Statute Sections 211B.06, which was deemed unconstitutional by the Eighth Circuit Court of Appeals in 2014. And why this is important is it's a trap for the unwary by the statute remaining on the books. For folks who read through the statute to find an appropriate claim of action for their concern, Minnesota statutes doesn't give that person awareness that this particular law has been found to be unconstitutional. And then the remainder of Article 4 clarifies expedited timelines and day counts in fair campaign practices.
Thank you for your testimony. Senator Gustafson, anything more before I open it up to questions?
No, thank you for your time and consideration.
Thank you, Senator Gustafson. Seeing no questions.
Sorry, Madam Chair.
Okay.
I'm sorry.
I looked both ways.
I was looking the other, sorry.
Senator Curran.
Thank you, and Chief Judge Starr. I'm encouraged by our conversation and the portion that moves that your organization is moving to an electronic means or for greater participation for those that that first are uniquely aware of the rulemaking process, and then to provide greater value. It sounds like it's a great tool. And so members, if you haven't had that conversation, I think there's an opportunity for us to really connect the legislation process and bill status to the rulemaking process in an end-to-end life cycle. So I'm hoping that we have a conversation in our bill tracker and everything that the revisor's office does, which has new software, to link and to try and tie, if they're going to track a bill, there should be an opportunity to track it through the engagement of the rulemaking process, because their new software in the ALJ process will have that. And so it'd be really good. I think it would build great transparency and trust for everybody who wants to participate. You know, somebody who's tracking a bill, I come up as talk about 4685. You know, they're very passionate, they follow it, but it's very difficult today to do that, especially when a bill may be included in an omnibus bill. But I think there's an opportunity with the work that they're doing that we could really improve the process and in transparency. So, and thank you, Chief Judge Starr. Always appreciate your honest conversations and the work that you do. So thank you.
Thank you, Senator Curran. Senator Gustafson, would you like to move your own bill?
Yes, Madam Chair, thank you.
Senator Gustafson moves that Senate File 4891 as amended be recommended to pass and referred to the Judiciary Committee. All in favor, please say aye. 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 Opposed, no. The motion prevails, and Senate File 4891 as amended passes and is referred to the Judiciary Committee. Thank you, Judge. Senator Gustafson, if you could please stay with us and present Senate File 4600 at your convenience.
Thank you, Madam Chair, members of the committee. Senate File 4600 is a bill in response to compliance issues with water gremlin and the blood lead levels of their employees. That is very difficult to say, so I'm going to say it slow every time I see it. In 2017, the elevated blood lead levels of water gremlin employees' children surfaced, but no changes were made to laws stating acceptable blood levels. Workers with children affected by elevated blood levels were almost all within the current acceptable range, but the children of the workers could still suffer impairment as a result of lead exposure. Senate File 4600 would ask the Commissioner of Labor and Industry and Commissioner of Health to work together to lower the acceptable blood lead levels to protect employees and their families. Currently, Minnesota's Occupational Safety and Health Administration says that a worker must be removed at a blood lead level of 50 units and can return to work at less than 40 units, but the CDC states that even a blood lead level of 5 units can lead to a decreased renal function, and a blood lead level of 10 units is associated with increased blood pressure and hypertension. Several states have already updated their occupational lead standards to be within a more acceptable range. There is no safe blood lead concentration, but SF 4600 would work to create a new lead level based on current data and the effects of lead. Thank you, Madam Chair.
Thank you, Senator Gustafson. And my understanding is that we do not have any testifiers or any amendments on this.
That's correct, Madam Chair.
Thank you, Senator Gustafson. And this would be going to the Finance Committee. Senator Morrison.
Thank you, Madam Chair, and thank you, Senator Gustafson, for bringing this bill forward. I'm shocked to learn that we need this bill. Thank you for saying there is no safe known lead level. It can't be said enough. And the numbers that you read are exceedingly high. So this is important legislation, and I'm glad to see it move forward. Thank you.
Thank you, Senator Morrison. Senator Curran.
Thank you, Madam Chair and Senator Gustafson. So where are the areas that were discovered to have the high lead counts? Because I've done a few business tours as well, and one being an ammo plant where they have it, but there hasn't been any examples of any of the contamination or poisoning. And so are there more examples of where it's actually occurred, where we have, what are the trends today? Again, all of us followed unique and different things. What are the trends where we are seeing the elevated lead in individuals and their children?
Senator Gustafson.
Yeah, Madam Chair and Senator Cran, great question, and I probably should have mentioned that in my opening speech. This is a hyper-local issue, but obviously would help everybody across the state. The company that is the one that we are sort of battling in my district, and both me and my predecessor have worked to make sure that we are holding them accountable is Water Gremlin. Yeah, okay. Water Gremlin is a manufacturer of battery terminals and lead fishing weights in the North Metro. They've since gone out of business. They are now owned by a new company, but it took quite a bit of work working with both the DNR and MCPA to make sure that the permit was respectable to the people in my district. They are sick. While we addressed a lot of the concerns last year and in years before, what we found is that within the workplace, there was no monitoring of that. And so then when we dug into that a little bit more, we realized, as Senator Morrison pointed out, that just the different levels are, they have the level set differently for different agencies, and they're just not lined up. And so what we're trying to do is just say, like, what is an acceptable amount that you could be exposed to and still stay healthy?
Thank you, Senator Gustafson.
Thank
Senator
you, Madam Chair, and thank you, Senator Gustafson. Outside the localized, has there been a trend in that? Let's say maybe Senator Morrison. I'm curious. We've always talked about lead paint ingestion and those things. They're just not aware of any new or emerging trends, or is it just kind of the old historical, the same issues that we've had? I'm just curious.
Senator Gustafson.
Thank you, Madam Chair, and thank you, Senator Cran. I do have quite a bit of information here. I don't want to, not anticipating that question. I don't know if you want me to I can certainly give you the information offline. I don't have it in front of me, or at least it would probably take me a few minutes to read. I don't want to waste your time, but I'm happy to share those with you because I do know that other places are probably experiencing this.
Thank you, Madam Chair.
I'm hearing Senator Gustafson say she will have as much of this conversation offline as needed. Okay, thank you. Seeing no other questions, Senator Gustafson moves, I assume you'd like to move your own bill, moves that Senate File 4600 be recommended to pass and sent to the Finance Committee. All in favor, please say aye. Aye. Opposed, say nay. With that, the motion prevails, and Senate File 4600 has passed and will now be sent to the Finance Committee. Thank you, Senator Gustafson. Up next, we have Senate File 4142 with Senator Herr. Senator Herr, if you could please step forward. Welcome to our committee. And when you are settled, you can begin talking about your bill at your convenience.
Okay, thank you, Chair Mitchell. Today is a busy day for many legislators and also advocates as well. Madam Chair, I have one testifier, and I think he's still testifying in other committee, and he'll be here shortly. Mr. Pat River will be here shortly.
Okay, Senator Herr, I do not see any amendments on your bill. And just in the meantime, the specific part that is coming to our committee is a portion of the bill that authorizes rulemaking in Section 54, allowing the Commissioner of Natural Resources to use the good cause exemption and for rules to be adopted not to expire after 2 years.
Madam Chair, I can go ahead and summarize the bill.
Senator Herr, that would be wonderful. Thank you.
Okay. This bill in front of you, members, Senate File 4142, proposed policy-related and technical change to the Minnesota statute relate to game and fish programs administered by the DNR, which will help DNR manage the state's natural resource adaptively and respond to the public input. Regarding fishery management, the bill contains initiatives that clarify the DNR's intent on trout, channel catfish, and sturgeon fishing season, as well as updates public input requirements when the agency considers special and experimental season. The bill also includes recommendations made to the legislature regarding first previously classified as rough fish. The change allowed the DNR to manage Minnesota fishery more effectively and efficiently. Regarding wildlife management, the bill includes 3 policy changes related to elk and deer management and hunting. The changes would address concern related to the import of silver deer carcass, clarify when glazed orange is required on ground blinds, and help sustainably manage elk in Minnesota. The bill also includes an apprentice trapper certification program, allowing people to purchase trapping license without having complete trapper education if they were accompanied by a licensed trapper over 18 while setting and tending traps. In very short summary, this bill provides the agency the ability to efficiently manage state resources, incorporate requests from the public for changes, and ensure the intent of prior legislation is implemented and enforceable. And Madam Chair and members, the reason this bill is referred to the Committee on State and Local Government and Veteran is exactly what Chair Mitchell has said, and it's in Section 54 on the good cause rulemaking authority of this bill.
Thank you, Senator Herr. I would like to also add there is a section on there's a portion on Section 17 as well in full disclosure. Knowing that the testifier is not here and that might be the more appropriate person Do we have any questions at this time? Senator Anderson.
Madam Chair, would you repeat those sections that this bill has impact on that for us?
17.
Section 17?
And 54, Senator Anderson. And this would be laid over for possible inclusion.
And Madam Chair, I can talk a little bit about the rule change, the good cause rule change as well,
So do we have any questions at all? And then maybe we can see if Senator.
Is there a fiscal note, Madam Chair?
Mr. Anderson.
Madam Chair and Senator Anderson, a fiscal note has been requested but is not yet completed.
How about a local impact statement?
Madam Chair and Senator Anderson, I'm not aware of a local impact note request on this bill.
Thank you.
Are there any other questions whatsoever? Senator Drazkowski.
Thank you, Madam Chair. So you said this bill's going to lay over?
For possible inclusion.
Senator Hurd doesn't want it back in his committee. Does it have to go to Agriculture? Should they see the bill?
Senator, there was no request from Agriculture.
I know there's portions of the bill that affect agriculture, I'm told anyway. Senator Hurd, is it okay if we send it to Agriculture?
Senator Jasinski, can you locate where the section about agriculture?
Senator Drazkowski.
It references 17 and 17A, my notes tell me. I don't know which sections. I will look, Madam Chair.
Are there any other questions for Senator Hurd?
Is this still questions then, or section 17?
Senator Drazkowski, where are we at?
I'm told page 4, Madam Chair. Bottom of page 4 has a subdivision from Chapter 41A about an agriculture resource project. And I think there's Chapter 17 in this bill as well somewhere.
Ms. James is looking at it. Is our testifier here now? Can you proceed to while this is being looked at, please proceed and offer your testimony.
Pat Rivers, Deputy Director of Fish and Game with the DNR.
Thank you, Deputy Director. If you can please state your name and title for the record, and also in your absence, Senator Hurd did a pretty good job of addressing the bill, so.
Thank you, Madam Chair, members. For the record, my name is Pat Rivers, Deputy Director for the Division of Fish and Wildlife, the Minnesota Department of Natural Resources. I believe the Game and Fish Bill is here because of the use of expedited rulemaking authority or good cause rule exemption.
Thank you. We were able to cover that portion. While Ms. James is looking up the other issue, are there any other questions? We are going to lay this bill on the table. Unless Ms. James.
Madam Chair, it looks like sections 1 through 6 of the bill are in Chapter 17, which is an ag statute, ag chapter.
We are going to lay this bill on the table, and we will come back to it after Senator Hurd presents his next bill so that Ms. James has time to research the question. So Senator Herr, if you could please proceed to the next bill, which is, let's see, where are we on that order? Which would be Senate File 3905. If you could please present that bill, and then we will go back to the other one right after.
Okay. Thank you, Madam Chair. Senate File 3907 gives a popular and modernized option to the process and maintaining of fish and hunting licenses. Something similar to this, as an example, are our airline ticket. You can still have in paper form, but the most popular people just use their cell phone and scan it as they enter the gate. But this bill here and the DNR provide more to the process than the airline ticket. I'm just giving you an example. So Senate File 3905 provides the frameworks for DNR to successfully implement the new electronic license system, ELS for short, which will include a mobile phone app in March of 2025. The ELS is the primary system that issues angling and hunting licenses and permits to residents of Minnesota and visitors. The ELS also register and title outdoor recreation vehicles, including watercrafts and OHV. The new modern system will make it easier for customers to buy licenses, register their harvest, and sign up for safety training. It will also improve the business process for agents, registrar, and DNR staff. This legislation makes the statutory changes needed to allow people to enjoy the advantage of the modernized licensing system. It does not modify the underlying intent of our existing law. And in summary, this bill provides the changes needed to move the current licensing system to the new system once it's ready for implementation, and only includes the necessary piece to make sure that transition is seamless. I will have Mr. Pat Weber here, Deputy Director of Fish and Wildlife, talk about the required rulemaking of this bill, and will stand for any question that you may have, members.
And Mr. Rivers, before you proceed, this is in our committee today very specifically for rulemaking in section 50, which is line 2.71, if anyone wants to look at that. Within that framework, Mr. Rivers, if you could please proceed.
Madam Chair, members, Pat Rivers, Deputy Director, Division of Fish and Wildlife at the Minnesota Department of Natural Resources. As Senator Herr noted, we're excited about a new electronic licensing system to offer hunting, fishing licenses, as well as snowmobile classes, et cetera. To do that, we need to make statute changes, such as changing the term sticker to pass, and other kind of wording changes, and that is outlined in statute. And Section 50 of this bill would allow us to take the required rulemaking using good cause rule exemption to make those changes. There's no need to interpret what our changes are. Thank you, Madam Chair.
Thank you for your testimony. And to correct, I believe I said 2.71, it is 27.1. With that, are there any questions? Okay, seeing no questions, Senate File 3905 is laid over for possible inclusion. Thank you, Senator Herr.
Thank you, Chair Mitchell and members.
We will now return to Senate File 4142 with the answer that Chair Putnam declined to hear this, feeling that the change was more just clarification and not actually changing language in a way that agriculture would need to hear that. So That is the answer to that question. Are there any other questions on Senate File 4142? Seeing no further questions on that bill, Senate 4142 is also laid over for possible inclusion. Senator Hurd, did you have a final comment?
Chair Mitchell, I thank you for, first of all, thank you, but just have a question on the layover. Is it layover in the environmental bill or layover on the state and local government?
So it would, Senator Hurd, so it would be laid over, and because your committee acted favorably, you would be able to include it in your bill.
Okay.
Thank you. So it is laid over.
Thank you very much. Thank
you. Next, we are going to go to Senate File 3839. That senator is on their way from another committee. Oh, well, just in time. I was debating recess.
I'm here.
Senator Boldon, please proceed with 3938 at your convenience.
Thank you, Madam Chair and committee members. In front of you today is Senate File 3839, a bill brought forward by ARM, which is the statewide trade association of residential service providers supporting people with disabilities. This bill would exempt group homes licensed under Minnesota Statute 245A and small assisted living homes licensed under 144G from being regulated under a city, town, or county's rental regulations. The need for this bill came up from a growing trend of cities using their local rental regulations to keep group homes from coming into their cities and forcing them out of neighborhoods. This bill aims to protect the right of everyone to live in the communities they choose and to protect the people from NIMBY regulations that result in discriminatory actions against people with disabilities. Here with me today to provide more detail on the need for this bill is Sarah Grafstrom with ARM.
If you can please state your name and title for the record and proceed. I'm sorry, Senator Boldon?
I'm sorry, Madam Chair. I will just note that when, at the appropriate time, I do have an A3 amendment.
Yes, I am aware. We'll do the testimony. We'll go to that.
Thank you, Madam Chair. Good afternoon, committee members. For the record, my name is Sarah Grafstrom. I am the Senior Director of State and Federal Policy with ARM, a trade association of disability service providers. Happy to be in front of you today during Disability Services Day at the Capitol. We have over 1,000 advocates here today that are eager to meet with you all and talk about our legislative priorities. So to the bill, Minnesota is having a long overdue conversation about the importance of everyone having a place to call home. Senate File 3839 seeks to address an emerging issue with state law that threatens the constitutionally protected right to live independently and in a neighborhood of their choosing for people with disabilities. In recent months, we have seen news stories about cities revoking municipal rental licenses for various reasons, often ranging from neighborhood nuisance to overuse of emergency services. We've also heard troubling public comments from local elected officials, with one city council member suggesting Minnesota should go back to the long-gone era of non-residential settings and to, quote, realize that not everyone can live next door in a residential setting. We have heard proponents claim to need rental licenses to protect the residents living in the homes. Thorough and extensive licensing regulations with the Department of Human Services are already in place with group homes throughout the state, making them some of the most well-maintained care settings available in Minnesota. In fact, many cities look at the state regulations that are already in place specific to group homes and use that as reasoning to carve out group homes from their residential licensing ordinances. By exempting residential programs in permitted single-family houses from municipal rental license regulations, we are helping to ensure that people with disabilities have the right and choice to live in whatever community they choose, get rid of confusing patchwork of regulations which differ city by city, and retain the safety and quality standards which are already imposed by the Department of Human Services. Madam Chair, thank you for the time, and I'm happy to answer any questions.
Thank you. And since we started with the testifiers, if Mr. Berg could please testify, and then we'll proceed.
Thank you, Madam Chair and members. My name is Josh Berg, and I am a leader at a local nonprofit affordable accessible housing provider here in St. Paul, an ARM board member, and in my 10th year as city council for the city of Elko New Market, and an active member of the League of Minnesota Cities, and was appointed to the Metro Cities Board in 2021. As a local elected official, I know I'm supposed to be up here reinforcing the idea that local control is the only way to go on these issues. The simple fact of the matter is, however, that there are comprehensive state, county, and fire code oversight mechanisms already in place. In fact, we are held to standards that go far beyond what any rental license would ever require or protect against. This includes how services are being provided and that they are delivered by trained and competent staff, and also includes comprehensive physical plant requirements and inspections that ensure the health, safety, and livability of these settings. Local control in this case does not add anything besides an opportunity for local governments to continue to restrict where individuals with disabilities are allowed or no longer allowed to live. And because of this duplication just mentioned above, along with cities viewing rental licensing as not essential to ensuring the health and safety of residents, many cities already explicitly exempt these settings from their rental housing ordinances. I spoke with several city council members and staff from cities in the metro, and the resounding theme was, why would we waste valuable city resources to duplicate something another government agency is already doing and doesn't add any more value to any of our residents? The problem is most cities in Minnesota have no idea what they're doing in this area. The only consistency across the almost 200 city ordinances that I've reviewed is inconsistency as it relates to how, when, or if cities write and/or enforce our rental housing ordinance. Threats of or actual revocations and suspensions of rental licenses are happening in communities across this state, and cities are treating those with disabilities profoundly different than how we treat homeowners and other residents, including the many BIPOC owners providing culturally specific housing and supports to these residents. Quotas on how many rental licenses are being allowed are being enforced by cities both large and small, in urban, suburban, exurban, and rural communities across Minnesota. Outdated and cringeworthy terms and language are splattered throughout our ordinances. For the past decade, I have been working to remove these NIMBY-driven policies and practices that prevent our fellow Minnesotans with disabilities from living in communities that they choose. Unfortunately, communities continue to find creative ways to use local control to promote ageism, ableism, NIMBYism, and discrimination. Whether we at the local level like it or not, we need guidance. This is where local control turns into a statewide issue, and this bill will take one small but important step to correct. Thank you.
Thank you for your testimony and for your work in this area. Senator Boldon, would you care to describe the A3 amendment before we move it?
Yes, Madam Chair, thank you. So the amendment reflects technical assistance received from the Department of Human Services and inserts a different statutory reference to define community residential settings.
Thank you for that clarification. Senator McEwen moves the A3 amendment. Is there any questions on the A3 amendment? All in support of the A3 amendment, please say aye. Aye. Opposed? The amendment is adopted. Are there any further questions on the bill? Senator, was that a?
Madam Chair, yes.
Okay.
Thank you.
Senator Jasinski.
Senator Boldon, so just my comments as a longtime city council member and mayor, I think taking away local control is a serious issue, and I think that's a trend we do not want to do. Local governments are elected to make these decisions and look at zoning issues and neighborhood traffic and all those things that a single-family homeowner would like to see at least somewhat overseen in a local small town or any town, actually. So I'm not going to be in support of it. I think we're taking away local control from our local city councils and mayors and things like that is not the way we want to go. So thank you.
Thank you, Senator Jasinski. Senator Boldon, any?
Thank you, Senator Jasinski. I appreciate that perspective, and I guess I would reference back to the testimony that we heard where, local control is necessary, is useful, but also, we need to look at the effects of that, what is happening, and what is happening based on that is that people with disabilities are being harmed and pushed out of our communities, and so this is a way to improve that problem.
Thank you, Senator Boldon.
Madam Chair.
With
Follow up, please.
Senator Jasinski.
Just going back to that, so the city of Faribault has many, many group homes and assisted living, things like that. They've all been approved, but at least it goes through a local government, so they're not being pushed out of at least one city I know. Because of that, they go through a process. The neighborhood can input on it, and it goes through a process for that. They're not being pushed out of the ones that I know of. So I guess I would disagree with that comment. I mean, you can make that comment, but I don't think it's a fact to say they've been pushed out of all communities because of this.
Mr. Berg.
Thank you, Madam Chair and Senator. And thank you for bringing this up, too. And Faribault is a great example of a city that does exempt these specific settings from being licensed. So they would not be impacted by this bill whatsoever. And all but one of the cities in your district already exempt these settings as well. So I appreciate that, and Faribault is one of the good examples of how this is working.
Thank you, Madam Chair. Just to follow up to that, again, so local cities can make their own rules to make this happen. So they're not being pushed out. Local cities and local elected officials can make that decision to have them allowed without that. So again, it goes back to my point. Local control is good, and cities can make these decisions to make this happen in their communities.
Thank you, Senator Jasinski. Senator Anderson.
Thank you, Madam Chair. What are some examples of where this has been abused as far as cities not allowing these group homes to come and play?
Senator Boldon.
Thank you, Senator Anderson, for the question. I will turn to my testifier who can give specific examples of that. And I just want to clarify, I'm not saying that this is happening in every city, certainly, but it absolutely is happening, and we can hear where that is.
Ms. Grafton.
Yeah, thank you, Madam Chair, Senator Anderson. I think the most public example was a recent story last year in the city of New Hope where 3 assisted living licenses.
Could you speak into the microphone, please?
I apologize. 3 assisted living licenses were revoked. I think the big challenge for those particular 144G providers when their licenses were revoked, because being an assisted living provider, you cannot transfer your license to a different property. When that city revoked those 3 licenses for that assisted living, those people lost their home and and the provider lost his license to provide those services. So no other options to even move to a different city or town because their 144G license was tied to that property. And those were the comments that I referenced in my testimony where the city council member talked about the number of group homes in the city and the comment that he feels like not everyone really can live in our community. And so those are kind of the more egregious. I would echo what Senator Boldon said, that certainly not every city is doing this. But what we look at is if one person with a disability is being discriminated against, that's one too many people. And we want to make sure that everyone has a safe place to live and a choice where they get to live. I think we've seen other cities look at rental licenses. If there's an excess of emergency calls, for example, their rental license will be downgraded and they will have to go through a mitigation process in order to keep that rental license within 30 days or they lose their rental license. And we don't want people not to call emergency services if they need it. And so what we'll find is people are afraid to use those emergency services because they're afraid that their rental license will be revoked by the city. So those are just a couple examples. Happy to talk more.
Thank you. Senator McEwen.
Thank you, Madam Chair, and Senator Boldon for bringing this bill and to the testifiers, too. I really want folks to understand what it is that we're talking about. The state goes through and licenses these providers. They do extensive background checks and they do extensive licensing. And then people with disabilities move into these homes, oftentimes in their own communities. There is a complex array of services being provided. And if a city decides, we don't want them here anymore, and they revoke that rental license, those 4, 5, 6 people lose their place to live. They could potentially have a massive interruption in their services. Some people who need really critical care, like feeding tube or trach tube cleanings and day services and work opportunities. I mean, it's very, very serious, and it's not a local control issue, because if somebody can't live in one community, they're going to live in a different community. And so we want to make sure that we're not pushing people with disabilities around the state into these pockets of the state where, people with disabilities and their group homes haven't been licensed out of existence. We want to make sure that people can live in their communities all across the state. This is an incredibly important topic, and we are seeing more and more of these kinds of comments. I mean, we have, I'm very grateful to my community. We have a group home in my community. There is one resident of that group home that has very serious issues and does require a lot of emergency service calls and some fear within the neighborhood. Nobody's proposing that they get rid of the group home. They're trying to look for better services for that person. That is not the reaction of a lot of neighbors. It's not the reaction of a lot of people. Sometimes it's just easier to revoke a rental license, and that massive disruption affects all of us, particularly as lawmakers who manage the state law budget and all of the services that people with disabilities provide, or are provided. So this is just important, and it impacts all of us. It's not really a local control issue. It is a state issue that deals with Minnesotans and their ability to live in their communities.
Thank you, Senator McEwen. Seeing no further, if you could please raise your hand when I look left and right, that would be really helpful. Senator Jasinski.
Thank you. And again, we don't have any issues with this in Faribault. Things work good. But if I'm a single-family homeowner and I'm next to a home like this and I'm getting 15 emergency calls a week, what do I do if this instance? So if there's problematic issues, how does the single-family homeowner let's just say a neighbor, and they're getting 15 calls a week, and I'm not saying this happens, I'm just saying what if this happened? What would the homeowners or the city's remediation, something like this would happen if this bill passes? So if again, you have a group home or something's happening and you're getting 15 to 20 lights and sirens happening a week, and you're trying to live peacefully in your home, what would be done in this instance if this goes through? Because I assume that if this is a problem in other communities and then they take that license away because of what it's doing to the neighborhood, if this goes through, what is that homeowner's action to do if they're in a home like that gets 15 to 20 lights and siren calls a week? Just a question.
Thank you. Mr. Berg.
Thank you, Madam Chair and Senator. I guess I'll first ask the question of what would we do, or would a city do, if it was a family-owned home, same type of setting. So if it was your home or my home and I have a mortgage, what would the neighbors do at that point? I guess I'd flip it back on that. Now, because it's a rental license or a different setting, because folks served in these settings are licensed through the state, the first stop for a city or the police department or any local concerned individual would be to call Mark. Now, the individual neighbor may not know that that's the right resource, but that's where I think having this discussion now and working with the league and metro cities to inform and educate a lot of our cities, we'll be able to bring this information to them so that they know for these types of settings, which everybody has access to a directory of, so we can see every group home or licensed assisted living in every one of your districts. If it's one of those settings, this is the step to call. Call Mark. Mark then is the centralized location for any issues related to vulnerable adults, and then that causes a whole triaging, cascading system to go into play. It could be going back to the police department to send somebody out there if there's a criminal thing. It could be getting in touch with the county licensure, case manager, or whatnot. And I think through all of that, the provider and the resident and everybody on that team is then involved in trying to find that solution, as Senator McEwen said. As a provider with my hat on, my goal is to make sure my residents are living the life that they want within the community that they want to be a part of. And when there's challenging situations, we're working with all the stakeholders involved, whether it's the city, the county, the state, neighbors. I mean, we're trying to be the best neighbor that we can. So really working together and encouraging that collaboration, I think, would be best. But a long-winded way of saying Mark is the point of contact for all of these settings, and how we get that information out, I'd be more than happy to discuss with the league and metro cities.
Thank you. Senator Anderson.
Thank you, Madam Chair. To the testifier's point about, you mentioned reference the city of New Hope. What was the citations that were made by the city against to the group homes that were wanting to establish themselves.
Ms. Grafstrom?
Madam Chair, Senator Anderson, I don't have that off the top of my head right now. I am happy to follow up with you with that exact information, but off the top of my head, I am not recalling right now what the citations were for those 3 homes.
Madam Chair.
Senator Anderson?
Well, if it's a situation where there's 6 or 8 or more people being living, and that's not part of the city's code to allow that many people to be in one location, then that's against the code that's already been established. I would think that if, we're talking here less than 6 people being in a group home, that the city had already had put standards in place to allow 6 people, or I should say maybe 5 people, to be in that group home. If that doesn't meet the guidelines, then it seems to me reasonable that the cities would say, you've either got to expand, and I know it's hard when you're in a city situation because you've only got a block or, whatever to be able to do that. But it sounds like the city is discriminating, and I'm trying to get to the bottom of saying, how did they discriminate? If they've already got it in statute for guidelines for such things.
Madam Chair.
Ms. Sandstrom?
Madam Chair, Senator Anderson.
Grafton, sorry.
So I don't know the specifics off the top of my head right now. I will say, as far as size goes, all of the homes that we are talking about and the homes that were in New Hope, they can't have they are regulated by the state that they can't have any more than 6 people in those particular assisted living homes. For the community residential setting 245D homes, we are capped at 4 at our license capacity. So if there are more people living in the home, that again would be a DHS licensing issue that they would then come in and regulate and take enforcement action on that provider to say you are over your license capacity and you're operating outside of your license. So again, there are other regulatory entities in place that make sure that that size capacity is not being gone over.
Well,
Thank you.
Madam Chair.
Senator Anderson?
Thank you. I've got several letters here. They have concerns from metro cities and from League of Minnesota Cities and things that they're concerned that by putting this bill into play, that it's going to overstep the bound of their being able to set guidelines for what a group home should look like. And the state, you said, from your vantage point, sounds like Health and Human Services are already decided that there's guidelines that have to be met. So if in coordination with the local city, I would think there would be, I don't know why this bill would be, I'm looking for discrimination.
Yeah.
Go ahead.
Madam Chair, Senator Anderson, I think, that's our point a little bit, that these guidelines are already in place by the state. The Department of Human Services is coming in and licensing the actual services that are provided in the home and setting these standards for each particular home. The county then comes in and actually licenses the physical home. So they're coming in every other year and going through an extensive checklist to make sure the property and the home is safe. And on the off years, when they're not being relicensed, they're still coming in and doing that safety check. So we would argue that there really is no purpose for the rental license beyond just as a tool to use if a neighbor, doesn't like the fact that they live next door to a group home and they're going to call and complain to their city. Well, now the city has this rental license tool that they can pull and force that group home to leave the neighborhood. So what we're looking at is saying there really is no oversight that the city provides that is outside of what is already regulated by the state and by the counties through extensive regulations and safety protocols that are in place.
Mr. Berg?
Thank you, Madam Chair. And Senator, too, I'd be happy to share examples. I didn't want to call cities out publicly, but, there are cities in every one of your districts that we could talk about some very antiquated, just language that needs to be cleaned up that was well before I was born and doesn't apply to situations nowadays. And I think there's some that are even violating some of the laws in 245A.11 subdivision 4 about the quarter mile rule and things like that that could be addressed. And I think part of what this is doing too is it's raising the discussion level where we just need to get on the same page. And there is no same page when it comes to any of this. But if you're interested, I'd be happy to reach out separately and talk through, each of your specific cities. I've gone through every city ordinance and trying to identify, where there's opportunities for education and to get everybody on the same page. And I think that's where it will be very helpful with me on my seat on the Metro Cities Board and active in the League of Minnesota Cities policy committees. I'm hopeful we're going to have some discussions this summer of how we can just do better as a state.
Thank you. Seeing no further questions, 3839 as amended is laid over. Thank you for your testimony. Senator Boldon, we also have 3460. If you are ready and could proceed, go ahead.
Thank you, Madam Chair and members. We're going to switch gears a little bit here. This is a bill. Actually, the concept was brought to me by a constituent, a care provider, who, and I'll note a letter from him is in your packets, who noted in caring for his patients the number of times his patients were not familiar with the medications that they were taking. And I can say this is a familiar concept to me as well, as I take care of patients in the hospital. They often are not clear on what medications they are taking and why. And so this bill would, and I will say I do have an amendment that is at the suggestion of the Board of Pharmacy, who has I've been in touch with and collaborating with on this language. This bill would encourage the inclusion of a couple of pieces of information on pill bottles. One is the complete and unabbreviated generic name of a drug, and the second is instructions written in plain language explaining the patient-specific indication for the drug. And the intent of this is to help patients be more aware and educated on what medications they are taking and why. I'll note it's not a requirement. It is an encouragement. That is intentional, and happy to take questions if there are any.
Thank you, Senator Boldon. Senator Morrison moves the A4 amendment. All in favor, please say aye. Aye. Opposed, nay. The amendment is adopted. Senator Boldon, any further comment on the bill before we open it up for discussion?
No, Madam Chair.
Is there any question? Senator Morrison.
Thank you, Madam Chair, and thank you, Senator Boldon. I love this bill. It makes so much sense. It seems like a common sense thing, but particularly for people who are taking multiple medications, it's very easy to get confused about which medicine is for what. When do I take it? So having clean, direct, straightforward language and the indication on the bottle just makes a ton of sense. Thank you.
Thank you. Seeing no further questions or comments, Senate File 3460 is laid over. Thank you, Senator Boldon.
Thank you, Madam Chair and committee members.
Senator McEwen. Senator McQuaid has Senate File 3204. When you are ready, please proceed.
Good afternoon, Madam Chair, members of the committee. Before you is Senate File 3204, which updates the section of statute that governs the Public Employee Insurance Program, also known as PEEP. PEEP is a health insurance pool that school districts, city, and county employees can opt in to join. The pool currently contains 289 groups and provides coverage for about 17,000 employees. In January, MMB, which is the agency that administers this program, conducted an analysis of the PEEP pool structure compared to other states with similar health insurance pools. One of the recommendations in the report, and what the DE will do, would increase the number of years groups are required to participate in the pool. Previously, groups were only required to participate in the program for a 2-year term, but as amended, this bill would require participation for 4 years. The bill also lowers the threshold for groups to exit the pool if their premiums if they increase by 20% rather than the previous threshold of 50%. These changes will offer some much-needed stability to the pool based on data demonstrating what works in other states. And stability to the insurance pool means lower health care costs for employees and for the state, and for that, I urge your support for the bill. And Madam Chair, I will move my bill and my amendment before the committee, if that's okay.
Senator May Quaid offers the A1 amendment. All in favor, please say aye. Aye.
Aye.
Opposed, nay. The amendment is adopted.
Thank you, Madam Chair. And with that, I can turn it over to my testifiers.
Thank you. I apologize for not having the testifier on the list. If you could please introduce yourself and state your affiliation for the record.
Thank you. Good afternoon, Madam Chair and members of the committee. My name is Adam Janiak, and I am in the Negotiations Department of Education, Minnesota. Thank you for this opportunity to talk about this bill that will help educators with the current crisis of rising healthcare costs. PEEP is a state of Minnesota health plan available to cities, counties, and school districts. PEEP leverages off the state employee plan, CGIP, and uses the negotiating clout of their size to offer very low administrative costs and multiple network carriers to the member groups. It's important to note that as we talk about pooling and group size, the larger the risk pool, the more predictable and stable the premiums tend to be. Although PEEP was created years prior, schools were first allowed to participate in 2009. Since that time, PEEP has played vital roles for the school groups, both small and large, across Minnesota. By ensuring competition in the marketplace, PEEP has saved districts and members over $100 million in premium dollars over the past 30 years. Additionally, PEEP serves an essential role, especially for our smallest schools, in that it is required to insure any public employer group. Other carriers can and do simply elect to not insure high claims groups. Last year's example is Greenbush Middle River. They had no bids returned from their RFP process except for PEEP, and PEEP was able to come through with a 6% renewal, which is significantly lower than what many groups are seeing these days. The past few years have been some of the most difficult in all areas for our educator workforce, and accessing affordable, high-quality health care was no exception. The pandemic created great volatility in the market, which stressed the ability of the PEEP pool to operate as it should. Participation in PEEP is voluntary, which creates potential challenges in the world of risk pooling, with mandatory pools being much more likely to be stable and predictable. But voluntary pools can still operate in a very beneficial manner and be successful when structured correctly. In response to these volatile times, MMB hired a consultant group to complete a review and study the plan to see what improvements could be made. The consultant had some very clear suggestions to improve PEEP using other similar programs across the country as comparisons. They shared ideas for participation, underwriting, plan complexity, and communication that could be very helpful to the plan. Currently, when a group enters or re-enrolls in PEEP, it is a 2-year commitment. This bill would extend that period to 4 years and increase the stability of the pool. When comparing to other states with successful voluntary pools, one of the most important factors was having a longer period of commitment. Stopping short of mandatory participation, the consultants shared this was the next best step. PEEP also has a renewal rate threshold built in that if a group reaches it, they do have the option to leave at an earlier date. Currently, that threshold is a 50% renewal increase, but this bill would lower it to 20%. This would not only increase the trust of those looking to join, but also demonstrate the intent of PEEP to operate as a large pool. With these changes, groups will be committed for longer periods of time and increase the stability of the pool. Giving school district employees the option for being in a more stable pool will help shield them from the rising cost of a healthcare industry that is draining working people's paychecks with no end in sight, given the lack of federal regulation in this area. We appreciate the committee considering these changes to PEEP.
Thank you for your testimony. Are there any questions from the committee members?
Madam Chair?
Senator Anderson?
Specifically, what are we, after we take all this bill out and we just go with the one, is there anything that we're specifically going over as far as the need for this? Except for the legal amendment and the going from a 2-year to 4-year and lowering the premiums from 50 to 20? I don't know what else we're supposed to be, there's nothing to do with rulemaking, is there?
Senator Anderson, why this is in our committee? The actual program is in our jurisdiction.
So what is the solvency of PEIP?
Madam Chair, I'll let my testifier.
Testifier, please.
Thank you, Madam Chair. Senator Anderson, PEEP is in a very good financial situation. There is an MMB representative here, though, if you want any more specifics to that.
Thank you. Senator Anderson?
I would.
If the MMB representative could please come down, state your name and title for the record, and then proceed with the answer.
Madam Chair, members of the committee, my name is Galen Benshuth. I'm the Enterprise Director for Employee Insurance at MMB, overseeing both the CGIP and the PEEP program. Senator Anderson, PEEP is in a very healthy position, right about at our target reserves level. So the answer is we're a very solvent, very healthy program at the moment.
So the need for going from a 2-year to a 4-year term?
In terms of our reserve level, we're at a really good point, but over the last, excuse me, Madam Chair.
Go ahead.
Over the last few years, we did experience a little bit of volatility in our premium rates, as Mr. Janiak from Education Minnesota testified, and we hired a consultant, outside consultant, to come in and look at the program and recommend what stabilizing mechanisms Minnesota should consider. And one of those was lengthening the enrollment term in order to avoid the instability that we did experience a few years ago. This was more of a proactive solution moving forward in order that we continue on a stable path that we're on at the moment.
Thank you. Senator Anderson?
Madam Chair, thank you. To decrease the premiums from a 50 to 20%? Is there some concern there?
Senator McEwen.
Thank you, Madam Chair. And Senator Anderson, the purpose of lowering that threshold to leave was to demonstrate the intent and confidence with this being a stabilizing measure, so that the threshold wouldn't have to be as high as 50% in order to leave. It could be lower at 20% because the confidence in this measure helping to stabilize the pool, we wanted to convey that to folks who are in it.
Thank you.
Seeing no further questions, Senator McQuaid has moved that Senate File 3204 as amended be recommended to pass and placed on general orders. All in favor, please say aye.
Aye.
Aye. Opposed, nay.
No.
Division.
A division has been called. Could all the ayes please raise their hand? All nays, please raise your hand. With 6 yeas and 5 nays, the motion prevails, and Senate File 3204 as amended will be sent to general orders. Thank you, Senator McQuaid. Next on the list is Senate File 4297. That will be me. I will be switching out if Senator Gustafson would mind coming to swap out with me.
Nothing, this was a delete.
When you're ready, Senator, and we believe, Senator Mitchell, you have an amendment in A1?
Yes, Madam Chair, and this is my first committee, so I move the A1 amendment.
All those in favor, say aye. Aye. Those opposed? You may continue.
Senator, Madam Chair and committee members, this would increase the ability for groups to monitor from a remote location, making the meeting available for such monitoring, including portions of the comment sections, so that people are trying to follow, much like we do here in the Senate, when someone comes forward and testifies or has a comment, that the outside public is able to keep up with what has been said on that level. With that said, I have a number of testifiers here today, so if we could go to them, I think they would kind of help illuminate what we are looking for a little bit better.
Thank you, Senator Mitchell. First testifier I have is Allie Furman, and if Kimberly Hafner could come to the table as well, we'll have you go next. I'm going to also have you state your names for the record, because chances are I probably got those wrong. So welcome to the Senate committee.
Right here. Go ahead, you can sign them.
Okay. Good afternoon, Senators. My name is Allie Furman. I am the president of AFSCME Local 2822. We represent 1,200 clerical workers at Hennepin County, and we are here today to support the public broadcasting of public comment. The way this bill came about was Hennepin County Commissioners passed a measure that would remove public comment from the actual meeting of county board members. And it would not be included in the public record. This followed years of our union and community members speaking out about public safety issues and safety issues around the pandemic at public comment during the board meetings. We were so effective at using public comment that they passed a measure to bar it. You will hear perhaps from public lobby groups from the county or other public entities that this is they're taking public comment out of public broadcast as a way to prevent the spread of misinformation. That is not true. This is about limiting democracy and silencing the voices of community members and of workers. Public comment is an essential part of democracy, especially for entities such as Hennepin County, which has public funds about half of the state. So it has a tremendous amount of money and power within the state, and our voices, both as workers and community members, should be at the table when they're making decisions about how that money is spent. Thank you.
Thank you. Ms. Furman, right? I just want to make sure I'm in the proper order. Thank you very much. All right, Ms. Hafner.
Yes, hi. First time being here. I'm so excited that I get to testify about open public comment. I believe, Kimberly Hafner, part of AFSCME 2822. I'm the chief steward of our local here today with our president. And I believe so deeply in the public being part of the public record. It is our duties to have open and transparent government. We want to be a part of the process. Government functions when we are at the table also, being engaged, having your constituents have their opinions heard. We want this to be working. We believe so deeply that what we do matters. And for Hennepin County to limit and silence the voices of not just union members, but the people they're supposed to be representing, we see this as a measure, as a stopgap to hopefully enshrine this in state legislature. So we get to protect the best parts of government and transparent government, and that is public record. And that is having a voice at the table for our officials to hear us. So I'm just so pleased again to be here to say this is important. This is important to the 1,200 members we represent. For Council 5 that represents 43,000 workers in Minnesota, this matters, and this matters to all of us. Thank you.
Thank you very much. Excuse me. Thank you very much for your testimony. We have two other testifiers, Matt Elling and Mayor Tim Buss, possibly Bussy. If you could approach the table and state your names for the records when you're ready. Thank you.
Madam Chair, members, my name is Tim Bussy.
I serve as the mayor of the city of Bloomington. I appreciate the opportunity to speak to you today in opposition, actually, to this. And I do want to say, after dragging my council through a 5-hour council meeting last night, I've got mad respect for the work that you're getting done here this afternoon, getting through all the bills that you're getting through. Madam Chair and members, as mayor, I am committed to robust and authentic public engagement. I fully understand that it's my obligation to provide opportunities for residents to engage and interact with their elected officials. It's also my obligation to ensure that city meetings reflect the business of the city of Bloomington. As mayor, it is not my obligation to provide a platform and an audience for people to make speeches or to further their own personal agendas. That point came into sharp focus when Bloomington was discussing how to conduct our public comment portion of our council meetings. As we consider changing our practices, I tracked participation in the public comment period during my first 2 years as mayor, 60 meetings from March of 2020 to March of 2022. In that 2-year time period, we saw 183 interactions as part of public comment period. In that time, 8 people accounted for 86 of the 183 public comments during that public comment interactions. That's almost half among 8 people. That is not good public engagement. And of those 86 interactions, more than half the time there was nothing for the council to react to or questions to answer. The council simply sat there and listened to someone make a speech, and that is not good public engagement. So we decided to do better. We made listening sessions meetings that are separate from the regular council meetings, and we moved them out of the council chambers, off camera, and into a nearby conference room. Now our interactions are conversations with residents, and the entire process is less formal and less intimidating for people. Everything is by the book. Listening sessions are regularly scheduled, they're noticed, we have a call-in option, there's audio recordings, we have minutes, and a report out at the council meeting after our listening sessions. In the 48 listening sessions that we've held in 2022 and 23, we've heard from 117 speakers. 73 of those speakers were unique or first-time speakers. That's more than 62% of new speakers who apparently found the new format to be better and a better experience. That is good public engagement. And it's been the darndest thing. Since we made the change and there's no longer the opportunity to grandstand and play to the cameras, we rarely, if ever, see any of those 8 people who I referenced earlier. Clearly, engagement with their local government officials wasn't really their goal. Madam Chair, Bloomington and other local governments do a very good job of engaging with their residents. I'd be happy to continue this conversation with you and the rest of the Minnesota legislature to discuss ways that state government could authentically engage with Minnesotans in ways that also abide by the open meeting law. Thank you.
Thank you, Mayor Busse. I do not see he is here, so we'll hear from Matt Elling. Please state your name for the record, and you can proceed with your testimony. Thank you.
Thank you, Madam Chair, Senators. If I'm slightly out of breath, I just ran from work, so I apologize for getting here late. To the points that were just made, this bill does not require a government entity to hold a public comment period. That is left to the discretion of the governing body. And we think that's appropriate. There'll be times when it's appropriate for governments to hold a public comment period. Sometimes they have to under law. If they're going to be discussing certain kinds of budgetary matters. But it's largely a discretionary matter. This bill does not change that. What this bill does is basically say, in the simplest terms, the public that's viewing at home should see the same meeting that's being seen by attendees in person. Because right now, you have certain entities like Hennepin County, the Roseville School Board, that are excluding the public comment section of their meetings. And when they hold that public comment section in an open meeting, it is part of the meeting, because a meeting under the open meeting law, excuse me, is a quorum or more members of a public body gathered together to do official business. So that's really what this bill is about. I know that the committee has a very packed agenda, so I'll just, excuse me, halt there, getting out of breath, and stand for any questions if you have them. Thank you.
Thank you very much. Members, any questions? Senator Barr.
Thank you, Madam Chair. Just to clarify, I think I got this, but I want to make sure I got it right here. So if this bill is passed, it'll just be gavel-to-gavel coverage on TV for remote viewing. There won't be any additional, the remote viewers won't be able to comment. It's just gavel-to-gavel coverage on the TV, and that's all this bill is mandating, correct?
Yes. Senator Mitchell.
Yes. Madam Chair, Senator Barr, thank you for the question. This is the intent.
Senator Barr, follow-up? Oh, Senator Drazkowski?
Thank you, Madam Chair. I generally like the bill. I'm just wondering, Senator Mitchell, what about sessions that are, if a board goes into session for negotiations or something like that, is that considered part of the meeting? And would that be caught up in your bill?
Senator Mitchell.
Thank you, Madam Chair. So my next bill actually has to do with when you can and can't close meetings and how. So I happen to be pretty fluent on that. If it is already something that is not required to be public, so that would be attorney-client privilege, contract negotiations, certain employee matters that you wouldn't want in the public, all those exemptions would still pertain. This is, if we're open, just like we are here today, just like we do, anyone who came up to the record to testify, we would not be turning that off and turning it back on.
Senator Drazkowski, follow-up?
Thank you, Madam Chair. Thank you, Senator Mitchell. Just the language, it says the entire meeting must be. So any additional clarity you can do there might be helpful, or maybe it's in your next bill. That's all I have. Thank you, Madam Chair. Thank you, Senator Mitchell.
Members, any other questions? Senator McQuaid.
Thank you, Madam Chair, and I'll go fast so we can get to your last bill, Senator Mitchell. But do you want to respond to the testimony from the mayor? Because the way I was hearing it was that they chose to do listening sessions which weren't publicly monitored, and so therefore they had more engagement, which didn't seem relevant to this bill. And so I just wanted to ask if there was any relevancy to that testimony shared.
Senator Mitchell.
If my testifier could, are you comfortable speaking to that, because he was a little bit more involved in that particular issue?
Yeah.
Mr. Elling.
Certainly. So the way this bill is structured, the public comment regulation comes in Section 2. So that's separate from the broadcast mandate. And the way that Section 2 is structured is that it requires two things. It doesn't require public comments, but it basically says if you're going to hold a public comment period, you should hold it during an open meeting. And that was specifically crafted that way because one of the things that attorneys for government entities have been doing in the last couple of years is saying, well, we're going to drop quorum numbers for our public body, and then we'll hold a public comment period because it's not a meeting under the open meeting law. So this addresses that.
Senator McQuaid.
Thank you, Madam Chair. And Senator Mitchell, I really like your bill, and I think even if it's just 8 people that we hear all the time, I still think it's important that that gets broadcast.
Senator Mitchell. Any other members? Oh, Senator Morrison.
Thank you, Madam Chair. Senator Mitchell, just a quick question. Does this bill in any way change a mayor's ability to limit the amount of time that people are allowed to comment?
Senator Mitchell.
Madam Chair, no, it does not.
Senator Morrison, follow-up?
Thank you, Madam Chair, and Senator Mitchell.
Members, anyone else? All right, seeing no other further questions or comments, Senate File 4297 as amended will be laid over. Sorry, I didn't know where the gavel was.
I took the annotated thing, but I left you the gavel.
Thank you.
Okay.
All right, Senator Mitchell, you're up again with Senate File 4132.
Thank you. This is Senate File 4132, and I would like to move, of course, after all of our discussion, that this would be recommended to pass and referred to the Judiciary Committee. This, I am going to go fast in the interest of all of our time because this is the last bill that we have tonight, and it's standing between us and coming back this evening. But this spawned out of an actual incident that happened in my community where attorney-client privilege was being abused, or the claim of attorney-client privilege was being abused to have a closed meeting, because that is one of the exceptions. And then in a closed meeting under that, you are not required to record the meeting. So, and it was a pretty egregious case that it was posted that it was going to be a closed meeting to talk about a contract related to the school district on a Friday of a holiday weekend. The school district had no idea that the contract was going to be discussed in closed doors about them without their consultation. They tried to talk before the Wednesday meeting on a Tuesday to say, what's going on. their attorney, the school district's attorney, even called the city attorney and said, you cannot close a meeting for attorney-client privilege because attorney-client privilege under the state of Minnesota is only if there is an active lawsuit, and you can only close it specifically to talk about the lawsuit. If you do any other business, you have to open it back up. I think most of us know this, or if there's a specific threat. So I'm filing in court against you tomorrow on this issue. So the school board attorney even said, we've never threatened a lawsuit. There is nothing pending. If you have this meeting, it would not comply with Minnesota state law. And a city in my community still held it. They made an official decision in closed doors, so even if you're having attorney-client discussions, anything else like an official city action should not be done behind closed doors. And then when community members showed up at the next meeting and said, what did you do? We don't think this complied with the law. The city refused to release any data on it. It went to an advisory opinion with the state. The state came back and said this was absolutely inappropriate. This closed door should not have happened. The community members said, okay, release the recording because you have to, record meetings. They said, well, attorney-client privilege, we did not maintain any data whatsoever. Recordings, emails, anything, so that anyone in the community has any right to see now what went on in this meeting. As I dug further into what the community could do with this response, because a lot of people were upset, we found out that the laws had not been updated in 30 years. So a person, the attorney fees are pretty limited, so community members would pretty much have to come out of pocket to take the case to a judge to get any sanctions on bad actors. The sanction at the end of the day, if you do this 3 separate times over years, then maybe you couldn't hold office anymore, and it would be a $300 fine. And talking to city council members, and my House member carrying this with me was a city council member. He said, yes, it's so hard for anyone to meet all these standards and actually have anything happen, and then a $300 fine. We were pretty much just told, don't worry about it, because if you ever, don't follow these laws, because it's impossible for the community members. And especially with the kind of death of local news, that used to be who was holding these things accountable. They would help with the lawsuits. And now it is really all on the community members to do this. So this law does a couple things. One, it says if there's going to be attorney-client privilege, you now have to state as you're closing the meeting, which you don't have to currently do, what the lawsuit is, so that they're actually having to say, yes, there is really a lawsuit, and not just like saying attorney-client privilege and then, just using that as an excuse to have a closed-door meeting and not record anything. 2, it does ask them to record, and you are probably going to hear, well, that would cause a chilling effect. We wouldn't be able to have that conversation if it's recorded. But the safeguard is that is not required to be released, and we do record all other closed-door meetings. So there's already procedures in place to do this for contract negotiations and other things. And it would never be released unless the case goes all the way to a judge who would review it only in camera, which means it wouldn't even go before, jurors or anything. If a judge reviews it in the context of a lawsuit, only then could it be released if it is found that the privilege didn't actually exist and was abused instead. And then finally, it allows community members a greater recovery of their legal fees so that they could even bring these cases forward, and increases the fine from the level set in the 1990s of $300 to the first offense being $1,000. So to me, this is really a bad actor bill because for someone to get through all these wickets, we want it to be more than like a little slap on the wrist, which is kind of what it currently is. So that is everything behind this bill. It's a fascinating story. I don't want to tell it all now. Get me offline. I will tell you what happens. But that's where we got to how we are here with this bill.
Thank you, Senator Mitchell. And before we get to the testifier, I understand you have an amendment to move?
Oh, yes, I do. Hold on. Not?
Stand by. Senator Mitchell, we do have an amendment. Would you like to just take a moment?
I'm sorry, I have I thought that was with my last one. I apologize. This is my first committee stop. This gets it in the order. So basically, this changes it so that anyone could file the lawsuit to making sure it was someone within the community if they go to the extent of trying to file one of these lawsuits. So I move the A1.
All those in favor, say aye. Aye. Opposed? You may proceed. Are we on to your testifier?
Please.
The amendment is adopted. Mr. Elling?
Yes.
Thank you.
Yeah. Thank you, Madam Chair. Senators Matt Elling, Minnesota Coalition on Government Information. I will be very brief and will mostly be here to stand for technical questions. I think Senator Mitchell has done an admirable job not only of putting this bill together but of explaining it to you. The only thing I would add that is in the bill that would necessitate a little more backstory is that there's a provision that was changed because of a 2018 Minnesota Supreme Court case. Since the open meeting law has been put into statute, there's been the ability to remove an official who violates the law in 3 different instances. Then a judge can determine whether or not to remove that individual. There was a series of lawsuits stemming from activity in the town of Victoria prior to 2018 that resulted in a finding of 28 sustained intentional violations of the open meeting law that were found by a judge in a series of consolidated lawsuits. These were 3 different lawsuits, I believe, brought together and consolidated as one action. So then the parties moved to remove the officials who had all been found to at least have violated the open meeting law in 6 or more instances. It went all the way to the Minnesota Supreme Court, and the Minnesota Supreme Court said that you can't do that because they have to be not concurrent but successive back-to-back lawsuits. It can't happen as a matter of 3 different violations or more found in one action. So this updates that to basically say if there are 3 intentional violations that have been found, then you can seek removal instead of doing 3 back-to-back lawsuits, which would, with the appeals process, take probably more than a decade. So that's the change made there, and we think it's important. Thank you very much.
Thank you, Mr. Elling. On virtual, online, we have Morgan Kastner. If you could state your name for the record and then proceed with your testimony.
Morgan Kastner, and I'm a parent, a PTA member, and a longtime Woodbury resident. And I'm very concerned about the City Council's failure to hold an open meeting regarding school resource officers in District 833. After this happened in September, I reached out to Public Safety Director Officer Jason Posel immediately for clarification on the sudden and rash decision to pull all school resource officers from the schools. And he spoke to me on the phone at length. He was planning on calling each person in the city. I don't know. I can't imagine that you can physically call each person to explain your rationale for that. So the only effective way to communicate with every single member is to hold an open meeting and record it on city property. Officer Posel is not even an elected official. Ann Burt, Andrea Date, Steve Morris, Jennifer Santini, and Kim Wilson have all been elected to their positions and are legally bound to hold open public recorded meetings. And to this day, I have no idea where each of my council members stands on this school resource officer issue. When I addressed the council on September 27th about holding that closed meeting, they responded it was their right to do so, claiming attorney-client privilege. They disregarded the law, and to me that's shocking. I've lived here for more than 15 years, and I'm not sure they even recorded the meeting, which as a community member, I know I can always go back and look at the recordings if I miss them, as is my right. I attend school board meetings, and I've noticed when they're just deliberating with their attorney, they do so in a public open meeting so that the public can see it. Elected officials have a duty to provide transparency when conducting business on behalf of the body they serve. I have a 12th and 8th graders in the school district, and these directly affect their lives. My city council members failed to provide transparency and should be held accountable for their actions so they do not continue to do this in the future. This bill directly addresses that, and I urge your support.
Thank you. We have Mayor Bussey next, or anyone else who cares to testify. I have you on the list, sir. I'm sorry to put you on the spot, but well, you're on this list too, but that's okay. We'll take you off. Anyone else who cares to testify on this bill? Please state your name for the record and proceed when you're ready.
Thank you, Madam Chair. My name is Shep Harris, and I am here today representing the Minnesota Association of Townships. And thank you for this opportunity. I'll try to be brief. The townships have had some good conversations with Senator Mitchell, and definitely want to say thank you to her and to the committee for considering what the goal of the bill is. And the townships agree it's a good goal in terms of the concept of the transparency and the documentation. I just wanted to give you a quick sense of what life is like on the ground in some of these townships. Some of the more urban townships or townships closer to regional centers have the capacity and have the financial capability of being able to do this. But for the vast majority of the over 1,700 townships, especially in greater Minnesota, it is a challenge. And so as this bill moves forward, we encourage you, if there's some potential opportunities for finances to help some of these townships, that would be greatly appreciated. The average size of a township is 500 people. So you can imagine and I do not have off the top of my head what the average budget is for those townships, but it is a hardship for them to deal with the technology to deal with this proposal. Now, some of you might say, well, just pull out your phone and why don't you record that? Just alone, and I found out earlier today in the past year, there's been 3 cases that the Township Association has heard about where there have been town officials who have done the recordings on their phone, but then they've refused to turn that information over. So what happens is that then you go to the local law enforcement to deal with the enforcement issues. In some cases, law enforcement has, because of the relationships, the nature of the close relationships in a town of 500 people, law enforcement has actually refused to get involved. So then, in that case, the townships are being held liable and being punished as they see it, as opposed to the individual's actions. So those are some of the dynamics that we're working with at the local level, and so we'll continue to work with Senator Mitchell. We just wanted to educate the committee on that challenge of how we go forward in doing this, so that we can maintain that transparency and the documentation. So thank you.
Madam Chair.
Thank you, Senator Mitchell.
If I can clarify, townships have some general concerns, even not specifically related to this bill, because just so many places do audio or video recording now, and that might not be tenable. Specific to my bill, I've made it pretty clear that whatever they're currently doing, even if that's just someone taking notes, can be continued. And again, if it got to the point of someone having something on their phone, no one has to release anything, however it's recorded, until a judge, it would have to go a long way to violate the law, to go through an advisory opinion from the state, and then to go to a judge to say release it. But I know they have some bigger concerns in any type of, recording under the context of this law, even separate from the bill.
Thank you, Senator Mitchell. I represent the largest township in Minnesota, and even though it's the largest, it does have some funding challenges just because of the way townships are organized. And I know we have several members on our committee here who also represent townships. So it is nice to have that consideration, and I'm glad that you'll be continuing to work together with them. Anybody else? Members, any questions, comments? Yes, please come to the table, state your name for the record, and proceed.
Right. Good afternoon, Madam Chair, members of the committee. My name is Jared Shepard, and I'm an attorney and partner at the law firm of Campbell Knutson. My firm represents over 40 local government entities that are subject to the open meeting law. and I specifically represent the cities of Burnsville, Elk River, and Shorewood. I'm here today to express opposition to the proposed changes to the open meeting law on Senate File 4132. For those narrow situations in which elected officials may close a meeting under the open meeting law, only one is allowed not to be recorded, and that's meetings closures for attorney-client communications. That's because confidential communications between a lawyer and the client is a bedrock principle of legal representation. It is well understood among municipal practitioners that the exception does not extend to requests for general legal advice. In fact, the exception is to be invoked cautiously and seldom in situations other than in relation to pending or threatened litigation. Furthermore, in closing a meeting, and this is where I respectfully disagree with the senator, right now the public body must state on the record the grounds for such closure and the subject matter to be discussed. That is a requirement in law today. This requirement allows a check on the exercise of this exception through review by the Data Practices Office, which issues advisory opinions, or the courts. This is the process Senator Mitchell was talking about that actually worked for Woodbury. There was a complaint to the Data Practices Office. There was an advisory opinion which said this closure was improper. The amendments before this committee go beyond the purpose for a meeting closure, which can be reviewed right now, to allow for after-the-fact dissection of a legal advice between a city council and their attorney. The advice requested and rendered may include litigation strategy, an assessment of the strengths and weaknesses of the case, settlement of the claims, the advice on whether to remove a judge, which is allowed under the Minnesota Rules of Civil Procedure, or legal counsel's thoughts on opposing counsel or the opposing litigants themselves. In short, those communications potentially contain a host of sensitive discussion that requires honesty and candor between the lawyer and the client. Stifling such important discussions will reduce the counsel's ability to make good decisions, which could include the potential settlement of meritorious claims, and ultimately indicate that municipal corporations have less entitlement to the provision of sound legal advice than all other entities and individuals. Finally, the proposed amendments to 13D06 subdivision 3 would also provide that a city council member could be removed for a judicial finding of 3 separate intentional violations of the open meeting law. That's separate violations in one case. This change is problematic for 2 reasons. First, it creates the possibility of removing a duly elected public official before the adjudication that provides that official the opportunity to learn that what they thought was proper was improper. Recent judicial opinions hold that an elected official may be subject to removal by a court even without a finding that they purposefully or knowingly violated the law. As I understand, the intent of the forfeiture provision is to remove a knowledgeable repeat offender who willfully ignores our open government principles. Instead, with the current lack of clarity in the meaning of intentionality in the statute, an entire council could rely on the mistaken legal advice and all be subject to removal after one lawsuit. I do not believe that that is the intention of the forfeiture provision and would be counter to the will of the electorate. In conclusion, I respectfully request that this committee reconsider the proposed amendments to the open meeting law. Thank you.
Thank you, Mr. Shepard. Members, questions or comments? Senator Carlson.
Thank you, Madam Chair. And my question would be to the attorney. You mentioned Burnsville. That's one of my cities that I represent. I'm wondering, you mentioned that the council could be given poor advice by the attorney. What is the remedy when the attorney gives poor advice? Let me add on to that. Isn't it the responsibility of the attorney to stop that conversation and say you are now violating the open meeting law?
Mr. Shepard.
Madam Chair, members of the committee, certainly the legal counsel has a responsibility to its client to inform them of situations that might be out of compliance with the law. Obviously, councils and council members can make their own choices. But with respect to determining whether or not legal advice has been rendered or followed, again, there's checks to that. There's requests to the Data Practices Office for advisory opinions. The statute currently allows lawsuits related to potential open meeting law violations. And when we're talking about closed meetings, we're talking, again, going back to what I said, at the outset, is that the law currently requires the council to make a motion and to state the reason they're closing. In other words, the grounds under the open meeting law, which statutory subdivision that it requires, and then what they're discussing. So in the context of, and again, most closures under the attorney-client privilege are for pending litigation. So in the context of that, the council would say they're making a closure under 13D subdivision 5, subdivision 3B for a confidential attorney-client communication about the case, and then explain what that case is. And they do that on the record at the meeting. That's the requirement under law now. So if they didn't do that process, we would know by the minutes, by the video, whether or not the closure was proper. That same thing goes for other closures, real estate negotiations, labor negotiations, and the like.
Thank you. Senator Carlson, a follow-up? I don't mean to interrupt, but just to know that we have to give up the room shortly for elections, which you're the chair of, so thank you.
Thank you, Madam Chair. And I don't want to go into too much detail about this, but my daughter is an attorney in California, and she has found that exact same issue that Senator Mitchell has found, and has made a complaint. And they call their act the Brown Act. And the county attorney for Los Angeles has warned the school district twice now that they are breaking the open meeting law. And in fact, what we found out was that this was about a contractor that was working for the school district, and there's some major amounts of money that's involved. And in that case, there are citizens, members of the community that are taking that same action that Senator Mitchell has taken, and it's serious. And I'm getting the feeling that there's more and more of that going on, where the open meeting laws are being violated. And I think I'm really happy that Senator Mitchell has brought this up, and I support it fully. Thank you.
Thank you, Senator Carlson. Anything else? All right, seeing none, Senator Mitchell moves that SF 4132 is recommended to pass and refer to the Judiciary Committee. As amended, that concludes our business for today.
Oh, you have to take.
We need to vote on it. Sorry, everybody. All those in favor say aye.
Aye.
Aye. All those opposed? All right. Thank you very much. Bill passes. Motion prevails. Meeting adjourned. Thank you, Senator Barr.